Good morning, everybody. Good morning, everybody. I see that they have already started. I didn't know they were going to start this. Okay, but it is closing arguments. Red texted me and said, "Are you going to wear your pink?" I said, "Oh, is that a thing?" So I had to, y'all know my stuff is still in boxes. I had to find the first pink shirt I could find that looked decent enough to wear on here. So I have on my pink. Good morning, everybody. It is closing arguments day. Thank you guys so much for being so patient and understanding with me for yesterday. I appreciate it. I needed the time. I had an amazing day yesterday. Ended my day with family. Give me just a second. Hold on, y'all. Okay, sorry about that. But anyway, I had an amazing day. Good morning. I cannot believe we have made it to closing arguments. I just can't believe that we've made it to closing arguments. That is just, y'all, we've been here 30 days. Hold on, y'all. I got to move, Barchi. Sorry, I got both dogs over here today. But anyway, I can't believe that it is already time for closing arguments. It's been 33 days. 33 days. She said Melody Love. 33 days of listening to freaking Hank, who is worse than Lally. 33 days. We still don't know how John was hit. If he was hit. We don't know what happened to this man. 33 days later. 33 days later. Well, Forrest, if I were them, I wouldn't be in the courtroom anyway because you barely escaped that stand. Like, you barely escaped the stand. I was watching, I was watching The Lawyer You Know yesterday because I was in and out of court. What I can't understand is what the Commonwealth's purpose was this go around. And he made a great point. He said last trial, you had person after person after person testify that thank you, person after person after person testify. He didn't come in the house. We didn't see him, right? This trial, you only had how many people did you really only had Jen up there. You really only had Jen up there to say he didn't come in. Now, Ryan, his ex-girlfriend, they just said they didn't see him in the car. They didn't see anyone leave the car. That's it. No, can y'all see me? I heard StreamYard was messing up yesterday. And I hope it doesn't get me today. Because I believe The Lawyer You Know had to stream somewhere on Restream or something. I saw Kat talking about it. So I heard StreamYard was really bad yesterday. Y'all see me? Okay, cool. So yeah, I agree with him. Last trial, we did have all of these people. He didn't come in the house. He wasn't there. We heard it so many times, right? With all of those people from the house. This time you didn't hear it as often. So the jury can just, I think they can just assume more of what they want. And who cares about what the police say? People told them. They weren't there. They weren't there. Ash, I kept seeing it. I think I watched The Lawyer You Know before I went to dinner last night. And first of all, I'm just happy to know I am not the only creator that has technical struggles with these lives. Baby, he was going crazy yesterday. He was so bothered by that live stream yesterday. It was different. It's like that day I had to go on YouTube. I did not like it. I was so used to StreamYard, right? I was so used to StreamYard. And then I have to go on YouTube. Baby, it didn't work for me. It did not work for me. Hey, Hallie. It just didn't work for me, guys. It didn't work for me at all. Listen, no, Red messaged me yesterday and asked if I was going to wear pink. So the pink top is because Red told me, hey, she put the idea in my head. And when I tell y'all, it was a pink top sitting right here. I said, I'm going to wear that. I said, I'm going to put that on. Listen, that's what I'm going to be wearing. Good morning, Tasha. Tasha just put on a little pink top so that I could show my support. I really hope it's free Karen Reed, because baby, I hear there are a lot of anti-Karen Reed live streams going on. I just hadn't been able to catch one. But I hear some of our faves are having anti-Karen Reed parties, and I want to come. Good morning, Kay. It is closing day. She said, good morning, Mel and chat. Happy Friday, Kay. Let's go, AJ, in defense. I hear some shit with closing is going to be fire. I hope for a not guilty today. So Karen and Miss Reed can have a great Father's Day. Me too. Listen, Brianna, I had to pull out the pink Easter shirt for today. Okay? I had to pull it out, child. At first, I was going to wear a dress. But I said, listen, there's no need in me sitting here hot in a whole dress. So I opted for a pink top. Thank you, OLM. She said, justice for John O'Keefe. OLM, I noticed his gallery has on blue today. I did notice that. Yes, Kay. Jaleesa, the top is kind of giving Easter, but, if you know me, you know I love something like this, some big sleeves. So, I'm going to let Brianna have it. I'm going to let her have it. Good morning, everybody that's joining. Good morning. How are you all? Thank you guys for being here. Good morning. Good morning, y'all. I'm so overwhelmed. Mariah was like, your trial is ending tomorrow? I said, I think so. This has been such an amazing journey through all of the non-streaming days. You guys have been here, and I appreciate it. Everyone that found me from Karen Reed, thank you for being here. It has been a journey, okay? It's been a journey. What are we going to do when this trial ends? Because so many of you found me through Karen Reed. You're invested. Sometimes I lean and depend on you guys for information, and it's almost over. It's almost over. Shayla, yesterday I was again talking to Mariah, who hates for me to talk about court. She was just like, she said, was the cop black? I said, no, Mariah. He was a white male. She said, what? And they didn't investigate? They didn't look at, like, nothing about this case seems ordinary or what we anticipate happening for a cop to be killed. Haley, I want to roll on over to the cash out trial simply because it's very familiar. We got some familiar players in there. And I'm not going to lie, after reading the indictment, I am really interested to see what are they going to prove. No, Stephanie, you know how it works over here. I don't find the case. We agree on the case. So we sit down, we may be a random TikTok live. We might be on YouTube, but we figure out what we are going to watch together. It's never just me because I'm not the only person watching. It's a collaborative effort over on this side. So we just kind of see this is definitely a democracy. everybody kind of puts in, hey, what about this one? What about this one? We look at the details of the case, and then that's how we decide what we're going to watch. Yes, Erica. That if you want to say that we let the cases speak to us over here, like Trooper Paul. We let the cases speak to us, and whatever the majority wants to watch, that's what we typically go for. Oh no, Hallie, we're definitely watching this one. Good morning, everyone. We're definitely watching Idaho 4. Tam, I'm interested in the cash out case just from the indictment. Just from the indictment alone. If you guys were on here the day before yesterday, we read the indictment. It's so vague. I'm late. That's why I didn't do good mornings, because I'm late. Like the indictment is so vague. And then the witness list? The witness list pissed me off, because wait a minute, what case are we trying to prove? You said this was a RICO. All you have are police officers. That's the majority of the witnesses. I don't like it. Red, I haven't really seen the courtroom yet. Shay, it's not 30 years of evidence. It's not 30 years of evidence. And that's the only reason I want to watch it. Yes, Cash Out's trial has started. We missed yesterday. But y'all know, listen, I'm at home, so I'll get to make it up. But yes, Shay, that's the plan as well. Y'all, okay, look at y'all. Okay, I told y'all the Cash Out case, after reading that indictment, I'm going to go back to it. I was like, it didn't look like the YSL indictment, where you saw on this day, hold on, Nani, get it together, where you saw on this day, this happened. Like, you didn't see that. Good morning, Yates. Good morning. You did not see any of that. It was just kind of like, well, between this time, this is what happened, and then it would say the charges, but it didn't give us any specifics. It's very vague. It's very vague. Which indictment, Miss Jones? Because if you go look at my live, Aaron posted it. The trial is on Fox 5. That's who I saw. I'm streaming it. And if you guys want the indictment, go look at my live. Aaron posted a Google Doc link in there, so you'll be able to see it. Miss Jones, just go look at the live. You'll be able to see it. Yes, it just, I'm sorry. And it was a couple of Jane and John Doe's. And I don't know if that means they're going to keep their identities hidden from us, or they really just don't know who the person is. Because this time the prosecutor said there were going to be finances, right? We'd see financial documents and transactions. Is that only Cash App? What are we going to see in Cash App? Because the mom's lawyer said she's sitting there because of Cash Apps. They claim that the Cash Apps were received because one of the victims lived with her. One of the victims wrecked her car. So I don't know. But I will say, hey, Fim, I will say that when we went to look at his page, I don't know how. Do you guys remember they talked about us we're going to see Facebook, Instagram, and social media posts, but they didn't have them in the indictment like they did YSL. Remember, we would see on this day, this person posted a picture with him and these people, and they were throwing up YSL. We would see something like that. Now, I'm going to tell y'all, I don't know, but his Instagram, he's selling something, and it could be OnlyFans. It could be he's selling he's really advertising and marketing OnlyFans, which is not illegal. But child, it look like something going on over there. So I'm interested to see what they're going to say. All right, now I'm gonna get back to Karen Reed. So yeah, so just a long story short, that is one that we could take a look at. I think it'll be an interesting case. But back to Karen Reed, I just still can't believe that we're almost done. I can't. Hey, good morning, everybody that's joining. I can't believe that we're almost done. It's been 33 days. For those of you that watched the previous trial with me, we did that in about 15 or 16 days. So we've been on this trial for about 45 days, a little over 45 days, and it is about to come to an end. So we normally do a poll every day. Put your verdicts in the chat. 1 for guilty, 2 for not guilty. That's typical. We normally do that every day after court. It has been a firm not guilty for me. I don't think the Commonwealth has proved anything. I am not one to say that I'm going to go against what we should be doing as jurors, right? And that is looking at the evidence and what has been presented. They've shown us that Karen has been drinking. She drunk that night. We all know that. But have they shown us that she hit John O'Keefe with her car? That is the core issue of this case. Did Karen hit John O'Keefe with her car? I'm going to say this. After watching The Lawyer You Know yesterday, and I don't have a copy. I wish I did. I'll try to get my hands on it. He went through the jury instructions. There was an instruction about the Commonwealth and their presentation of evidence. I know that's right, Lily. Good morning. I know that's right. And they talked about that. They can really tell, the jury really can hold it. They can kind of add this when they're considering a not guilty if the Commonwealth presented all of the scientific evidence that they could have presented. Did they do all of the tests that they could have done? They didn't. Oh, and Rentschler pointed it out. The damn paint test, it was no need. Key, that's what we're trying to figure out. There was no need for that paint test. It added no value. So, I mean, think about that, guys. Like, are y'all trying to play with us? And I really want to know what went through the Commonwealth's mind when they opted for testing. Because you had to know that this test didn't prove anything. Why didn't you say, hey, we need this, we need that? The only answer is that if they performed those tests would not have yielded the results that they wanted. They know they wouldn't do it. Hold on, Ash. I just saw your comment. I didn't know Bev wouldn't let the officer come in. Yeah, she wouldn't let it in, which I still don't get. When the neurosurgeon got to come up there and talk about something that he had really no direct knowledge about. Well, not direct knowledge. It wasn't his specialty. I don't get that. Really, Key? Okay, y'all. Key is saying yesterday they had the cash out trial and there was no string. What? Caitlin, she needs all the prayers that she can get. I just want this to be over because my biggest problem is if it's a mistrial again, they'll try her again. Like, what are we doing here? What are we doing here? Child. Go look at Sue's tweets. Okay, Shanny. Uh-oh. Oh, I thought my phone died. I said, now wait a minute. Hold on, y'all. Shanny said, go look at Sue's tweets. What's popping off in court? I don't like that Bev only giving them an hour and 15 minutes. I hate it. Hold on. Y'all, what's Sue's name on here? Let me see if it just... Okay, I got her. Okay, Sue says, Special Prosecutor Hank Brennan has visited with Miss O'Keefe and the family. What?
You are unmuted.
What?
Can you set this up? Thank you. Plug it in here. I need to see that flash drive.
Now we'll
Set it here. I need my mouse too.
No, why do you think? Well, maybe just at this...
All right, so why don't I see counsel over here at sidebar? I've got my computer up.
Do we see Paul, y'all? Oh, the dad's there today. Okay. This is the third verdict watch that I'll be a part of. And they just never get easier. They never get easier. Another damn sidebar. Y'all, what's popping off? Oh, Jesus. Blue for John. Blue for John. Hey, Krona. Something is happening, Shani, because what do they have to look at on her computer? Unless she's going back over that instruction. Hey, Big Lou. I watched like the issue with her and the instruction, and she said after everything Alessi said, Alessi was basically saying your instruction was bullshit. It really doesn't tell the jury the full story. It does not admonish Hank in any way. It was bullshit. After all of that, she said, well, I did say the date. You did want the date, right? Girl, damn the date. We are talking about the fact that you did not tell the jury that Hank Brennan made a mistake and it wasn't Dr. Wolf. It wasn't Dr. Wolf. Oh, damn. I can see Hank now. I can see Hank now. And then the defendant doesn't care about Mr. O'Keefe's mom, and then Karen comes in, and I could just see Peg. I could just see it's going to be foolish. Oh, it's going to be foolish. Y'all know it's Hank. Did I hit him? Could I? The defendant herself thought she hit Mr. O'Keefe. I mean, did I hit him? Could I hit him? I don't know if I hit him. I mean, that's what I was saying. Like, really? I'm just pissed off thinking about it. Yes, the dad is there. The dad is there. I'm just pissed off thinking about this foolishness. It is, I can see it now. I see it now. They said the daddy got over here. Oh, Lord. Oh. I am doing closing arguments. I am, Key. I'm just so annoyed because the thought of the videos, I know it's Hank. No, Cron. I know that's not your at-work voice. I know it's Hank, y'all. I can just see him just every so often. He'll be talking. And see, now I'm going to tell you what's going to take the punch out of it. It's what's going to take the punch out of all of this is if he has to tell, can we pull up exhibit, boom, boom, boom. That's going to take the punch out of it because now it's the dramatics are gone. No, the dramatics are gone. If he has to say, and then the defendant said, I'm sorry, can you pull up exhibit 223 and put it up on the screen at 15 seconds? No, go back 3 seconds. Okay, right there. The defendant herself said, Like, that's gonna take it out. You just may as well not even done it. You shouldn't even done it. And if it goes that way, Hank's lost. Because I mean, y'all, when you put, they already saw the clips, Brashana, right? Yes, they've already seen them, but I mean, this has to flow. It's like a project, just think about when you're doing a presentation. You want your presentation to convey exactly what you want it. Like, it needs to say exactly what you're trying to get out. I am. It has to. Hold up. She said Yannetti is patting Karen on the shoulder, and Karen is nodding and smiling at her dad. Thank you. Good morning, Shataka. Shataka, have you made it back? Mel, are you Attorney Little? The lady in the middle wearing purple. She she must pick that up. Key, this'll do. Wait a minute. I'm not playing with y'all. Jury's got to be effing pissed off. They called them last night, told them to come early, asked if they could stay late, and Bev doesn't have her shit together. What the is Bev? You still on vacation, friend? I know that's right. I know that's right. Shataki, you been in vacation all week, a week vacation. I love to see it. Oh, I can't wait. I think my family, we're going to Disney for a week in July, at the end of July, I think for Kylie's birthday. So I'm excited about that. I've never been to Disney before, so I'm going to show out. I'm going to have a ball. I've never been before. Yes, I'm 38. My mom never took me. I need to go to her grave and talk to her about that, because why didn't you ever take me to Disney? Okay? And now I'm going to Disney, and I'm super excited. Super excited about that. Hold on. I think it's blue, y'all. I think they're supposed to be in blue. Get you some good tennis shoes. Kay, I keep hearing that. I keep hearing that I need to make sure I wear some great tennis shoes. DJ Mommy, just go, girl. They say we taking our inner child to all the places we wanted to go. We traveled as kids, but I can probably count on one hand how many times my mom took us to like a theme park or something. So yeah. Erica said you stole the car. You could have took yourself. Which I recommend Crocs and drink a lot of water. Oh, thank y'all. Ooh, I like that capture. I like the sound of that. Forrest said, I'm sorry, jury. We had to take care of some stuff. Nuh-uh, wait. Jurors, I'm so sorry. We had to take care of some stuff. It was unexpected. Listen, I don't want you guys to get worried, because we are still on schedule. Okay? We just like to thank you so much for your patience. And we hope you get this case today, and you can go ahead and go into the deliberation room and do what you were brought here to do. Bring some justice. We thank you. We thank you. Good morning, Ronnie. No Crocs. Okay. Okay, no Crocs. Okay. What kind of shoes would you guys recommend then? Damn, the whole chat. Hell no. Hell no. Oh, okay. My bad, y'all. My bad. My bad. My bad. Good morning, Emily. So what would you guys recommend? What kind of sneakers? New Balance. Which ones? Oh, somebody keep telling me about, is it pronounced Hoka? They keep telling me about that. New Balance. Let me see. Those y'all, I ain't gonna even lie to y'all. I'm not gonna lie to y'all. Why is the soul so damn big on them? On clouds. Let me look these on clouds up. That's why I love y'all. Y'all just be putting me on every. What the hell is the on cloud? On cloud. I seen these before. Okay. I'm gonna have to go in a store. Y'all, these shoes, they just y'all, they are why is the sole so big? Why the sole so big on them? I mean, look at that. Now I'm gonna tell you this, Red. You think the 9060s are comfortable like that? Okay, on clouds, not for walking for a long period of time. Good, because I don't want them. I don't want them. Y'all, a lot of people have said that these shoes are so comfortable. Mariah loves 9060s for cushion. Them some he said them some orthopedics. Well, these on sale, y'all, for $115. I might just get these. I might just get these. I mean, these shoes make me feel like I can bounce. I can bounce like at my front door and I'll be right at my mailbox. I'll be right there. Hey, Bill. I mean, I'm gonna have to tell myself that this is comfort. Comfort over cute. I'm not getting on any rides, maybe some kiddie rides in Kittyland, but I'm not like a rider. Yeah, but just I planned on having a really cute outfit first day. These not gonna go, so maybe I need to carry a backpack where I can take my cute pictures, put those shoes in the backpack, and then put the hokas on. Are they hokas? Am I saying it right? Are they hokas? Am I saying that correctly? I hope so. I'm gonna get these ones they're $115. Girl, they don't even, do they not make my size? I wear a 6. Don't get the blacks. Don't get the black ones. Okay. Mel, just take pictures from the ankles up. Okay, well, they don't even make my size. Yeah, baby feet. Yeah, they don't make my size. They start at the 7, so I'm gonna look somewhere else and see. Oh, they youth section. I'm gonna have to go in the store. Now, Dick's Sporting Goods got those other shoes y'all told me about, the On Clouds. They got them on sale, look like. No, oh, they do have a 6. I'm gonna go in a store. Try A6. Okay. Miss Davis, I make fun of everybody I see in the hokas. Every time people walk past me, I say, look at them big ass shoes. Get a 7 and put some thick socks on. When I say I love y'all down bad because y'all really helped me out. Okay, I'm just gonna have to go inside of a store and try these on because I don't know how they run. Maybe I need a 7. I don't know, but I'm gonna go try them on. Khalees, I have some. Hold on, let me see if I see them. Hold on, y'all. Let me see if they in here. Okay, wrong shoebox. I had my feet scanned. I did everything. It's a place here. I thought Mariah was gonna run track. I had this one day. She did this movement, and it's like I saw her running track. I was like, "Oh my God, Mariah! I think I just saw you running track, and I think you need to try to run track." She has these long legs. She told me she considered running track, so we went and got her feet measured. Mind, we had them scanned. This whole process. Bought freaking two. That shoes was like $200 or more. Some type of running shoes. Can I tell y'all, this girl didn't even try out for the damn track team. Okay? Didn't even try out for the track team. So now I'm stuck with a shoe. I wear a 6. This man convinced me that your shoes are supposed to fit a certain way. He's probably right. I don't know. But I have a shoe that's a size 8. Every time I put it on, it looks like I'm wearing my husband's shoes. Okay? Like my man left me with everything but this pair of shoes. The shoes are so big on my feet, and I just refuse to throw them away because they cost too much. I'm not going to throw them away, but they are huge. Emily, I'm gonna have to post a picture of these big ass shoes, y'all. I mean, these shoes are so big on my feet. They're too big.
Good with that. All right, so the court, please.
Did I ever? I'm gonna have to tell y'all the story. I never told y'all I was married before? Did I ever tell y'all that? I was married before. So technically, it could have been my husband. The missing witness was Chloe. I feel like I tell y'all so much. Mariah says I overshare on my lives. I just don't think I'm really embarrassed by much. And I mean, we could really talk about a lot of shit. But yeah. Mel, you not a rider. They what? Yes, he knew he was married. Haley, that's exactly, you know what? I couldn't think of a person. Or you remember, I don't know if y'all ever watched Doug Funny, when Doug bought those big sneakers, they were too big for him. Yeah. Man, I was telling my man something about you, and he said, how the hell you know that? Jasmine, I don't think I tell any. I mean, if it's just that private, I won't say it. But some stuff, I mean, it doesn't bother me. It's okay. It's okay. Because you said that, Mel. I'm asking because I've been told different. I think this is the point of the conversation where I'm going to say, I don't know what the hell you're talking about. I think I'm not getting what you're saying. I think, I think, I think I'm not getting what you're saying. What is going on in this chat today? It's 9:33. It's 9:33. Whoa. What? What is going on in this chat so early? Oh my God. Oh my God. Or maybe as far as talking about focus, we gonna focus as soon as they start because I don't know what's going on here. Denise said, Mel, my son thinks you're so pretty. Oh, thank you. Tell your son thank you, Denise. Don't go spreading rumors. What? Ooh. Please start this court trial. Please start court today. No, Dave, we know you been. I didn't do anything. It's Friday. We need to start court. Let me make sure the stream is up to date because see, it's early. Y'all done came in here. I think y'all are just like overly excited. This trial is finna be ending. So y'all just cutting up. Y'all are cutting up today. It's y'all like, dang, this might be our last day. Let's go ahead and cut up early. damn cutting up tonight. Let's cut up early because that is just absolutely insane. She said this chat get cut away. Y'all need to like the live. I don't know what's going on. I'm with Forrest. Why would she have them come in at about 8:30 to start an hour later? I want to know what's going on, and this is not helping me. What is going on? Hold on. Let me see if Sue said something else here. Hold on. Let me see. Dang, y'all, I can't believe it's the last day. Let's see what Sue talking about. Y'all, it said the defense and the prosecution returned to their desk. The judge has left the bench. There's a 5-minute recess. What the hell is going on? I don't get it. I don't understand. I'm trying to see if there's anything else out here. I did see yesterday Turtle Boy was found not guilty for the violation. And I think Matt McCabe's brother was testifying in the clip I saw. I really do think so. Hold on. Everybody seems to be wondering the same thing. Why the hell hasn't court started? Yeah. I don't see anything extra. And I do see what Bev denied. Alice, no. Yeah, yes, Hallie. Rulings on a video. They have a motion to ensure transparency in the alternate juror selection process. She denied that. I'll read that. I'll read that in a little bit. Good morning, Alex. Good morning. Bia, I think the chat is just always bored. The chat is bored. The chat is always bored. They're trying to make use of the time. Yeah, I can't wait to read this motion. Why would she deny it? Because again, I think it was like last time, she wants to choose the alternate. She has been watching the jury just like the defense has been watching them, just like the prosecution has been watching them. And I think that's their issue. We know you were just playing. We just playing right back. So I think that's the whole issue. And Bev, I don't like putting it in Bev's hands. We can. Do you guys remember when, I don't know if you watched yesterday. Yesterday, Bev said, well, some of those clips could go to consciousness of guilt. And I can read this instruction. I really think it might help your defendant, help the defendant. And I said, this is Bev saying this. This is Bev. If they wanted it, they would say it. But this is her saying it. Good morning, Nene. The black man who doesn't take notes will be the jury foreman. Okay, Forrest, we're gonna see. I don't know, Lauren. I don't understand why she's making it difficult if she doesn't have some type of skin in the game. They said the defense was smiling. Let's see what happens. I don't trust her, Alex. When she made that statement, well, some of these, it could go towards consciousness of guilt. I can read this. And they were like, no, we don't want it. Are you sure? There's great language. Damn it, if they wanted it, they'd ask for it. Oh, yes, Summer. Sending your baby some love and prayers. that he has a successful procedure. I'm sure we'll still be here. So just let us know. Ooh, hey Ronnie. Ronnie said this Friday ain't nothing changed. Y'all in here chatting it up but haven't touched the like button. Stop being lazy. Hit the X and like the damn live. Thank you. Yes, Summer. We'll be in here. So she said I'll be here. Let us know how the baby's doing. Bev doesn't want to help the defense. I think she wants whatever that instruction is out there. That's what it is. Whatever that instruction. And when I was listening to the instructions yesterday, I think you can infer things from them. So maybe there's something in there she wanted the jury to hear. And they said, no, ma'am. No, ma'am, we don't want it. You can keep it. You could keep it. Summer, is this the baby you showed me yesterday? I mean, the other day? Or is this one of your older babies? I didn't watch Bev reading the instructions last year. Anna, I think some people are like, oh, skip this part. This is boring. But me personally, I like hearing the instructions, right? I like hearing what the judges are telling the jurors and how they should decide certain things. I like it. Oh, Summer, I hope he's good. I hope he's good, Summer. I love it. These are lay people, right? I'm a lay person. I'm not an attorney. So I need you to explain it to me in a way that I can understand it, where I can go back to that deliberation room and come back with the verdict, with a justified verdict. That's what I like. Who? Anthony Brown. Who is that? Let me look it up. Oh, Lord. Oh, Antonio Brown. Dang. I won't, Hallie. Don't worry. Antonio Brown. Okay. Well, when firing the weapon, I wondered how that was going to go anyway. So, Kay, I wondered how that was going to go. And honestly, they let him go right afterwards. So I'm interested to see how that'll play out. I'm interested to see how that's going to play out. And he really was defending himself. Yeah, Princess, I'm interested to see how that's going to play out, because what changed from then and now? He was let out and was on the stream right after it happened. So, yeah. Stephanie, what I saw yesterday, there was. But I don't know how to feel today, y'all. I don't know how to feel today. I feel it should be a not guilty. They haven't convinced me. And I watched last trial, came into this one. Okay, what's going to be different? I think it's very telling what they did with Dr. Welcher. Jessica Hyde, you can't be paid. You literally said that you have to use multiple tools. And then when it came time in December for you to rewrite this report, you used one tool. And that one tool conveniently took out the Haslong information. Okay. Ian Whiffen told me that Apple's phone does not know how to distinguish a hill from stairs. Ian Whiffen changed his time to line up with the Commonwealth's theory. I don't like it. You don't have to do that. You don't have to do that. So for me, it's no. Key, don't be mad at me. We're friends. Okay? We're friends. Don't be mad. I just can't do it. I don't. And then Shayla. But Shayla, why didn't they give him the x-rays? Like, if I'm a juror, these are things that I am thinking about. You gotta know this the second trial. Send that woman home. No one, Becky. No one. It does, Sarah, but we're gonna send those persons.
All persons have any business before the Honorable Beverly Canoni, Justice of the Norfolk Superior Court, and before the country before. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Good morning, jurors. Good morning. So I have started far too many mornings by saying to you folks, I apologize for the inconvenience, having you wait around so long. I appreciate your patience. I didn't want to do that today, but I had to do that today. Everybody has worked so hard on this trial, the jurors, the lawyers, the witnesses, that everything has to be right before you hear it. So I needed to do that this morning. So I apologize. I do have to ask you those 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we were here yesterday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here yesterday?
Yes. Yes.
So as you know, it's time for closing arguments. And when I was a trial lawyer, I never liked it when just before closing arguments, just before I stood up, the judge would say, jurors, remember, closing arguments are not evidence. But it's true. Closing arguments are not evidence. The lawyers aren't witnesses. And because they're not evidence, I need you to put away your notebooks because you can't take notes on them. But the reason it used to bother me is because I sensed that it made it sound like they're less important than anything else in the trial, and they're not. They're certainly a very important part of the case. And we've all noticed that you've paid very close attention to this case, and we know that you'll do the same to the closing argument. A couple of things I want to say, and you'll hear more about this in greater detail when I give you the charge. First is, you folks are the fact finders. So it's what you find from the testimony, your memory of the testimony. This has been a long trial, but your memory of the testimony, not the lawyers and not mine. So if the lawyers or I say anything that doesn't square with your memory, it's your memory that serves. Secondly, there are very important constitutional rights that I hope that you understand, or constitutional concepts that you need to understand. First, again, the burden of proof in this case is proof beyond a reasonable doubt and to a moral certainty. And the Commonwealth bears the burden of proof. Right? The burden of proof is on the Commonwealth to prove beyond a reasonable doubt and to a moral certainty. And because of that, in Massachusetts, because the Commonwealth has the burden of proof, the Commonwealth goes last in closing arguments. I've given each lawyer an hour and 15 minutes, and I'm not going to stop them. So we'll start with the defendant's closing arguments. Mr. Jackson?
Come on, AJ. Let's go.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today, presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true,
This is good.
your vote must be not guilty.
Come on, AJ.
If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain.
Can't be.
Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look.
It's giving the dramatics. It's giving the dramatics. It's giving the dramatics we needed. Ain't no stopping.
Sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor in his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John.
He did.
A gesture that looks a lot like, let's step outside.
Right.
Let's go outside.
Whoop.
But John looks at him, takes a swig of beer, completely ignores him. Take a look.
Sure did. Look at that. It looked totally different this go around.
Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing.
Nothing.
He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview. You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You come in here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car, out in the cold, in the middle of the night, she got frustrated and she drove home. She arrived back at home and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home at about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy, in any fashion, any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own experts said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert.
Y'all, not that man. No, y'all. He said Welcher.
John didn't even have a bruise.
Now he used Welcher.
Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV.
No
Period.
in hell.
Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, Photograph on the right. It's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rinchler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints, and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites.
Ooh.
He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen?
Let's talk about
Somebody
it.
needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it.
That's all.
And even in that basic demonstration, he had to lean in to manipulate it to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon?
Exactly, AJ. What?
What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:30 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that.
What is the problem, AJ?
And somewhere in the middle of trial, somebody must have realized it.
Ooh!
They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating.
Yep.
How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact.
Come on now.
And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess.
And what's
Question.
she gonna do? Lie?
Can you believe him? Can you believe Mr. Burgess?
No.
He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question.
Yeah,
That
thank
was
you
a
up.
shame.
Thank you up.
Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified, he came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision.
Say it again.
Just look at Mr. Whiffin's data, Ian Whiffin.
Liar.
John O'Keefe took 31 steps at a steady rate, about 83 feet, and then think about this, in a westerly direction.
What's
That
what?
would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffin himself conceded
Liar.
that he has reasonable doubts about the accuracy of John's location data. You remember that question and answer on cross-examination by Mr. Alessi? Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation, this is science, and it's irrefutable. It tells us that he was not laying outside in the cold, he was inside somewhere a little bit warmer. Ian Whiffin told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours. Never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement
Or a garage.
or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside.
Hey,
Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step.
dang.
What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. LaPosada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rinchler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car.
Not one.
Not Dr. Scorti-Bello,
Nope.
not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene.
Sure didn't.
The lame excuse offered by retired Lieutenant Gallagher: it was really cold and windy, and I didn't know if there was a crime that had been committed.
Liar.
What? You didn't know that a crime had potentially been committed?
The man dead.
You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away.
Right.
And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen in a house 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit?
He said, nope.
Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously, to get this done. His friend then asks what Proctor's probably thinking at the time, quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass. No ass bitch. She's got a leaky balloon knot. Leaks poo. Zero chance she skates.
Hey.
She's fucked. And up to this point, Michael Proctor had done zero
Oh, he's
investigation.
So dramatic. I love it.
Nothing. Save talk to a grand total of 3 people, all of whom were named Albert or McCabe. That's it.
Ooh, I
And
love
this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up.
Not a big old thumbs up.
He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder. No bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him,
Ooh.
how can you trust him with this
Ooh, that was
investigation
good.
and with your verdict
Good.
and with Karen Reed's life? The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from him.
They sure did. Call him out.
Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses, and for bias. Not just any bias, bias
In
this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness, is who had access to that shirt and who had access to those taillight fragments, and the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog.
I love him.
Oh, and the one sample of DNA that they did find, by the way, was found on the outer, smooth part of the housing. Not any shard. It was the outer, smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't.
Yes.
And they won't because it doesn't exist. that SUV never hit John.
Oh, I love him.
The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds.
Come on now.
But that little magic hair just clung there, just hung on.
It's stuck there.
That same hair that moved in between photos in the Sallyport. Remember that? There were 2 photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the 2 photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard. The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed.
What's she saying?
Because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper
Oh, yeah.
didn't match the cocktail glass.
Sure didn't.
None of it.
Come on.
Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those 2 go together. The only 2 things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash. Didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. That vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point.
Nothing.
Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning?
Hey.
When police dash cam video, you saw the dash cam,
We
it shows
did.
plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn.
I believe that.
He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? He wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me.
Oh.
He was in the house.
Mm-hmm. He had to be, y'all. That's the only place.
But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth has presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe grudgingly had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Witham, the Commonwealth's own expert, using location data on John's phone showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house?
Oh, good point. People have said this, y'all.
Question.
People have said.
As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever, not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for alleged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5.
Yes.
She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door to the garage? I was asking her about the front door, the side door, and the garage door, and her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Read. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning?
Oh, it was a warning.
We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins. But Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked.
He didn't give it to him.
And what about Brian Albert's dog, Chloe? A dog with a history. A dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She's
No.
just gone.
Jen
And
didn't
then
see.
ultimately gotten rid of altogether. Who gets rid of their family pet?
Some sick
Unless they had
people.
something to hide.
Exactly.
Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight.
Tell him the man.
Matt McCabe,
Come
whom
on.
the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly,
Exactly.
exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that
Let's
read,
talk about it.
Hoslong to die in cold. It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it?
Come on.
Why delete it?
Let's talk about it.
If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia?
Hypothermia.
Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation of her claim that Karen said Google hypothermia is this fantasy about Karen screaming it at the location, at the scene. That's her entire excuse. But that story went completely off the rails when Carrie Roberts admitted that she perjured herself to back up Jennifer McCabe's false story.
She did.
That was a dramatic moment in court. It's an admission
was.
of perjury, and you don't see that very often in a courtroom. That tells you everything you need to know about the character and quality of the prosecution's case and their witnesses. Lying and perjury and admitting
She
to
was
it.
so dumb with it too.
A fundamental tenet of any investigation is to ensure that witnesses are independent and not influenced by other witnesses. You start by separating the witnesses. Michael Proctor did none of that in this case, and we see the results. Think back to Jennifer McCabe's own text messages with Carrie Roberts. About Carrie Roberts, not with Carrie Roberts, notably. What Carrie Roberts didn't know was at the time she was being interviewed by the police, Jennifer McCabe was in real time She was bragging about having influenced Carrie's testimony or her statements to the Alberts and the McCabe's. Quote, she's telling them everything, all the stuff. Remember that timeline that we talked about with Jennifer McCabe? That's what she was referring to. She's telling him everything that Jennifer McCabe had put in Carrie Roberts' timeline. The Commonwealth wants you to believe that Karen Reed made a statement at the location, at the scene. I hit him. I'm sure you'll hear that from the prosecution in their final arguments. But their own witnesses contradict that.
Come on.
Jennifer McCabe admitted on cross-examination that her very first statement to law enforcement, confirmed that Karen didn't say anything. She asked, could I have hit him? Did I hit him? Is he dead? The physics and the science answer that question. Could you have hit him? No, you couldn't have. Sergeant Buchanan also testified that the only statements Karen Reed made at the scene, according to his conversations with the first responders, was, could I have hit him? Did I hit him? It wasn't a confession. It was confusion. And Dr. Russell explained that confusion. She told you why Karen Reed or anybody in that position might ask those questions. She was suffering from extreme grief reaction, which according to the evidence can last for years. Even her medical records confirm that diagnosis. It's common to ask those questions in grief. It's common to ask those types of questions in shock. You're trying to make sense out of the nonsensical in the moment. And the Commonwealth has tried to twist those words into a confession. There is no evidence that any officer at the scene ever heard Karen Reed say, I hit him. Not a single police officer at the scene came in to support the Commonwealth's claim. It's not on video, it's not on audio, it's not in a single police report, it's not in a single EMT or EMS report. Nowhere.
And I don't believe it.
The fact is, Karen never said, I hit him. You saw the video. Multiple officers were right there. She simply never said it. What did Jennifer McCabe do and not do when she got to 34 Fairview? She would have you believe, I want to set the scene for you,
Said it.
that she's confronted out of the blue with John O'Keefe's lifeless body. Her friend, John O'Keefe.
Ooh.
He's bruised and battered. He's bleeding. His eyelid is cut. His nose is bleeding. Karen is screaming at the top of her lungs. Carrie is screaming back to Karen, shut up! Both women begin crying. Both women are giving CPR. There's chaos everywhere. It's building in the yard, just feet from Brian Albert's house. Brian Albert's window. Jennifer calls her sister at 6:07. With all this chaos going on, no answer. Jennifer calls her sister at 6:08. With all this chaos and bedlam going on, still no answer. No lights come on in the house. In the midst of all this screaming and this chaos, Brian Albert doesn't come outside. Nicole Albert doesn't come outside during this maelstrom. And yet, Jennifer McCabe never goes inside to check on her sister. There's literally no signs of life inside the house. And Jennifer McCabe doesn't take a step inside that house to check on her family.
Damn, he
Why
probably got
is
about
that?
15 minutes left, y'all.
Does that make any sense? Everyone would sprint inside the house to make sure that there's no one in there that was hurt or injured or, God forbid, dead. Everyone would do that. But not Jennifer McCabe.
Again.
The only way that makes sense is if Jennifer McCabe already knew that Brian and Nicole were just fine. That's the only reasonable explanation. And the only way she would know that they were fine is if she knew what happened. But Michael Proctor never explored this incredibly suspicious behavior. Don't you have questions? This would give anyone reasonable doubt. And don't you have questions also about Brian Higgins? Michael Proctor certainly didn't. Higgins had been sending flirtatious and romantic texts to John's girlfriend, Karen Reed. You'll remember I asked Sergeant Buchanan a simple question. Were those texts flirtatious in nature? He refused to answer that simple question. Do you remember that? Quote, I'm not comfortable putting a label on that, end quote. We read the texts. It's not a secret.
Right.
Of course they were flirtatious. Of course they were romantic in nature.
He just ignorant.
The reason he refused to answer that simple question is telling. It's because these flirtatious texts establish a motive for Brian Higgins.
You're just ignorant.
Sergeant Buchanan could not bring himself to tell the truth. His bias was on full display. He was covering for another cop. Investigators also ignored Higgins' suspicious late-night visit to the Canton Police Department. That was after a night of drinking, by the way.
Talk about that.
Why didn't they investigate this? What was so important that Higgins needed to go to the police station at that time, 1:30 in the morning, while drunk, by the way? Why weren't they interested in those facts? Remember, he's an ATF agent. He's a cop, a member of the Blue Wall, and best friends with Brian Albert. He would know that the CPD would be the first to get the call when someone reported John missing or injured. He would know what to look for, what to listen for, to determine if a report had been made and when and what the response was going to be. You saw the skulking through the hallways with his hood up, moving bags between cars, and of course, that late night mysterious phone call on his cell phone, a phone that you don't have
He didn't make.
and that you'll never see. All of that, and Michael Proctor never gave him a second look. All of that, and the Commonwealth, who's supposed to be after the truth, didn't call him to the stand. If you have any unanswered questions about Brian Higgins, that's reasonable doubt. The police didn't interview Brian Higgins on January 29th, 2022, but he was at the police station, as we've just seen. You heard evidence that Higgins and Chief of Police Kenny Berkowitz, also good friends, were in the Sallyport together with the SUV for a, quote, wildly long time.
And then tried to lie.
Kelly Dever, another Boston cop, told you that.
Call a diva.
She also told law enforcement agents that she found it, quote, weird that Higgins could have access to that very sensitive evidence, the SUV. Folks, there is never a situation in which a witness, a potential suspect even, should be given access to the evidence in a case. But that's exactly what happened here. Higgins was given unfettered access to that SUV and its taillight nearly immediately, according to Kelly Dever's statement to law enforcement. And it was at that exact time, the exact moments that Higgins would be in that Sallyport, that the 42 minutes of the Sallyport video is just missing. It's just gone, vanished. Well, that's convenient. Now put in context the condition of that taillight when it was actually seized in Dighton. It was cracked, but not completely damaged. I ask you to compare and contrast Officer Kelly Dever, her attitude, her demeanor. That's all for you to judge. Her attitude, her demeanor, her truthfulness, her motives from the witness stand. Compare and contrast that to Sergeant Nick Barrows. Who's more believable? Officer Barrows is unattached to any of the players in this grand play directed by Michael Proctor. He's truly independent. And what did he tell you? Was the taillight, he was asked, was the taillight in this condition when Michael Proctor picked up that SUV at 412? His answer? Absolutely not. Absolutely not. It was cracked, but not completely damaged, not smashed out like that. So how did the taillight get cracked? How did it end up in the condition where it was cracked, as Officer Barrows saw it, but not completely damaged? Well, you don't have to guess. There's a video. Just watch.
Oh, okay.
That's how it got cracked. And Judson Welcher's own recreation confirms it. Look at the contact. That's from the Commonwealth's expert. And that further is confirmed by the fact that there were no taillight pieces found in any of the initial searches conducted at the scene. 2 searches, 50-foot area searched. Not a single fragment was found until after Michael Proctor had access to and control of that SUV and its taillight. What does that say about the character and quality of this case? It's revealing what happened here at
Yeah,
trial.
4 minutes, y'all. Thank you, Alice.
One of the most dramatic moments probably of the trial, Kelly Dever. How can you trust this investigation when you saw how far a police officer will go? You had a front row seat to the power of police manipulation and police corruption, a front row seat. Kelly Dever was interviewed by a separate law enforcement agency, not a friendly department, not Boston Police Department, not Michael Proctor's MSP, a different independent agency. She told those law enforcement agencies in a formal interview that she saw Brian Higgins and Chief Kenneth Berkowitz alone in the Sallyport with the SUV. She was detailed, she was clear, she was unequivocal, she remembered the specifics, she recalled how it made her feel, quote, weird. She recalled how long Higgins spent, a quote, wildly long time, as she described. These are all incredible details to tell law enforcement. She couldn't have been clearer, she couldn't have been more specific. But then she's put on a witness list and she's subpoenaed by the defense. Oh boy. Then this rookie cop was called up to the police commissioner's office, the same commissioner that was the boss of Brian Albert. They have a meeting, a private meeting, and he says, wink, wink, nod, nod, we support you, Officer Dever. What else was said in that meeting? What else is reasonable to believe was said in that meeting? She claimed she couldn't remember. She claimed not to remember if he instructed her to do the right thing. But the commissioner of the Boston Police Department certainly said something to this rookie cop, and all of a sudden, that detailed, unambiguous, unequivocal statement to law enforcement became, what did she say? A false memory. Not I didn't say it. She admitted she said it. She admitted she detailed the entire story. She just said, it's a false memory. What? So she's called to the commissioner's office to make sure that she would do the right thing. That's why she was called. And now we know what that means. In her words, my entire career depends on what I say here on the stand. I'll quote that again. Quote, my entire career depends on what I say here on the stand.
Sure did.
You bet it does. That's how it works. And that's how we got here. At the end of the day, you have to ask yourself, can you trust the Commonwealth's case? Can you trust their witnesses? Can you trust their evidence? And here are a few of the highlights. A video that was played in a courtroom and sold as accurate. Turns out it was completely inverted, flipped backward, completely false. The test that formed the basis of their entire theory of the case. Watch closely
Look at him.
as Dr. Welcher stands as a surrogate. Is that a righteous test? Or is that a manipulation?
Manipulation.
Dr. Welcher tried to deceive and fool you by leaning into the car, manipulating the results of his own test. When the truth was revealed by Dr. Rentschler, the Commonwealth spent the next hour cross-examining him about how that test was meaningless. It actually didn't mean anything. Well, that's convenient now that we realize that it was a manipulated test, and it actually does mean nothing. It didn't represent the theory of the Commonwealth's case. That's what was suggested. That test does not represent the theory of the Commonwealth's case. Really? Then why was Dr. Welcher playing dress-up in John O'Keefe's clothes, or identical clothes to John O'Keefe, when he was holding a glass? Why was he holding the glass right behind the vehicle? And why was he standing with his right arm oriented to the right rear taillight if he wasn't trying to recreate the circumstance that is the Commonwealth's entire theory?
He wasn't trying
The
to.
Commonwealth stood up here with a straight face and told you they weren't trying to suggest that that's how John was hit by the car.
Then
Of
why-
course
why
they were
did
trying
you
to
do it?
suggest that's their theory of the case. They only abandoned it 2 days ago when it was revealed by our experts
Uh-oh.
that it's physically impossible That silent witness, that science, that physics, has become very pesky to the Commonwealth because there was no collision. Dr. Welcher also told you under oath that there were no x-rays taken of John's arm. He tried to deceive you into believing that John's arm might have been broken. I don't know. I didn't see any x-rays, so I can't tell you what the damage was inside the arm. Really? The Commonwealth has had those x-rays in their possession for 3 years. And again, it took the defense to bring out the truth. The x-rays do not fit the Commonwealth's theory, so you weren't shown. And Dr. Welcher wasn't going to admit it. And my goodness, then we get to the sweatshirt. That was a moment.
It was a moment.
Mr. Brennan stood here in front of you and dramatically held up John's sweatshirt. Not just to the witness, but to you. And asked Dr. Wolf about it multiple times. Specifically, while it was in that plexiglass, asked Dr. Wolf about the multiple holes in the back of the sweatshirt. He interrupted Dr. Wolf, and Dr. Wolf started to look at the sweatshirt and say, well, and he said, how about here? Here's a hole, here's a hole, here's a hole, here's a hole. Dramatically tapping on that plexiglass. It was clear what the suggestion was, that the holes in the back of John's sweatshirt were from January 29th. That's the impression that was expected to be left with you. That's the impression that he wanted to leave with you.
And then it was a
And
lie.
that's false. The truth is, the Commonwealth created those holes. They aren't holes from road rash. They weren't made on January 29th. Those are cuttings from the Commonwealth's own crime lab, folks. That's what those holes are. And even with 3 prosecutors, all 3 of them, sitting right there in the room at the time, it had to be the defense to correct that record, to bring out the truth. If we hadn't done that, what impression would you folks have been left with? That's more than negligence. That's dangerous. It's dangerous.
Hey, Caitlin.
I'm going to guess that Mr. Brennan's not going to say much about this, about the fraud that was attempted on you. And if he doesn't, that speaks louder than any concocted excuse that the Commonwealth might come up with. It's shameful. It's shameful. We are after the truth in this courtroom. You're entitled to it. Demand it. Why would the Commonwealth stoop to a stunt like that?
Because desperate.
It's desperation. They know what you now know, what their experts know. There was no collision.
I keep thinking he's going to end right there.
So now we've reached the final moments of the trial, and you've seen the facts and you've seen the evidence, and we've just talked about dozens and dozens and dozens of facts that are reasonable doubt. Each one of them are reasonable doubts. These facts, these note cards that you're looking at, piled high, one on top of another, literally stacks and stacks of them covering the table. As you mentally sift through those cards, realize that every one of them is a massive hole in the Commonwealth's case. Every single one of the note cards represents a hole in the Commonwealth's case. If you're holding mentally even one of those cards, you're holding reasonable doubt, folks. You're holding a not guilty verdict.
Oh, I love that.
Reasonable doubt is not a sliding scale. It's a wall. If the Commonwealth cannot get over every one of these dozens of walls, you have to acquit Karen Reed. The truth is, Karen Reed is not guilty. Not because of technicalities, but because the facts, the law, the science, the physics, the data, they all say so. They demand it. The Commonwealth does not have a theory about how John was hit by the car. They haven't even shown you that it's possible that he was hit by a car. And the reason they haven't is because it's not possible that he was hit by a car. There was no collision. Your job is not to do their job, their burden entirely. It's theirs. They have to prove this case and their theory beyond all reasonable doubt and to a moral certainty. And not only do they not have a theory, they can't prove one that doesn't exist. All you need to know is that the Commonwealth failed. They failed to provide you with a truthful representation. They failed to prove the essence of their case, that John was even hit by a car to begin with. They failed to prove any intent on the part of Karen Reed because she has none. They failed to investigate the actual suspects in this case. They failed to present the lead investigator to you. They failed to justify the perjured testimony that you heard discussed in this case. They failed to hold accountable an officer who came in here and lied to you and claimed false memories so she could do the right thing to cover for a fellow cop or cops. They failed to maintain a fair and unbiased and honest investigation. They failed to present you with the truth.
They did not.
And this is what you get. An investigation that's riddled with errors and omissions and a rush to judgment and conflicted and corrupted from the start. Every part of it. That is the literal definition of reasonable doubt. How can they ask you to be morally certain based on this evidence? It's a tragedy. When the government fails so completely, so catastrophically, when there are dozens and dozens of points of reasonable doubt on the table, your duty, your oath is clear. Your sworn obligation under the law is to acquit Karen Reed, not just because you can,
Me too.
because you must. Justice demands it. Do not let the Commonwealth get away with this. Don't let them get away with this. Do not endorse and sanction an investigation that is broken and corrupted top to bottom. But just as importantly, do not let Michael Proctor get away with it. And make no mistake about it, folks. If you convict Karen Reed of anything, if you convict her of anything, science, the physics, the data, they lose. But tragically, Michael Proctor wins.
That's so good.
Remember his texts. Something stinks. Yeah, but serious charges will be brought on the girl.
The girl, a grown
She's
man.
fucked. Could you ever say to yourself, this is justice? The fact is there was no collision. A car did not kill John O'Keefe. So I ask you, let your voice be heard, not in whispers,
Haley.
but in truth. Let the community feel through your verdict that justice cannot be bent and that it will not be buried. Find Karen Reed not guilty, not guilty, not guilty.
Ooh, that stare. You did that, AJ. You did that. You did it. I'm his party ass.
John O'Keefe was 46 years old.
Now we care
46
about
years old.
June. Now we care about June.
He spent his life helping people.
And y'all ain't
He's
here.
described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people.
And y'all are not.
When his niece and nephew had nobody, he took them in.
He had
He
their
took them in.
grandma. He had their grandma back there.
John O'Keefe.
Hold on, before we get too far, y'all look at the lady how she looked at Peg when he said that, because he's just a liar.
He took them in.
Look
He
at the
was a
lady right
good
here.
man. He helped people.
Look at how she.
When his niece and nephew had nobody, he took them in. He took them in.
They had grandparents. Shut up. That's lying.
John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29th, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying, and he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help.
Why would Hank say that shit?
And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world.
Why would he
But to
say
give him a
this?
chance.
Why
And
would
that
he?
one person who could help him that morning was this defendant right here, Karen Reed.
Hank, Brian Apple was in the
And she made
damn
a
house.
decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard.
Wow.
She made a choice.
This was ignorant.
She didn't call
This
911.
was ignorant.
She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away.
Hank, that was just stupid.
She was
Stupid.
drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking at McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data.
Hank,
The black box,
what did it
the
say?
forensics from the SD card, we know exactly step by step where they were. We know in that window, she hits him because he never moves again. His healthcare data, the temperature on the battery of the cell phone, the physical evidence, the debris field, the DNA, the hair,
The hair.
and then she left him to die.
Shut up.
He had a basal skull fracture, counter coup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die.
Now this is terrible. And live together, Kate.
She was drunk.
Y'all, this is terrible. Why did he do
And
this?
that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described for you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28,
Y'all was
2022,
assholes. I hate to
because we
say
have the
it.
text messages, not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read
Oh,
him, you
she
saw
killed
them.
him?
This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So Keith drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos.
Ow.
You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober?
So sick.
And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide 1, please?
Uh-oh, here we go.
At the waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins. Barely greeting
And
each
then he
other.
realized it was smoke.
Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe.
Y'all, he going from the
In the celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
Didn't I tell y'all?
My alcohol intake's probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like old soda water with lime.
I told you.
Slide 3, please.
And look at this. It's not together. It doesn't
I
hit.
wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15. I mean, it was quiet, the roads were very quiet, you can see on the videos. And I was going, when I've had a few drinks and I drive, I always drive extra slow, so I know my alerts aren't as sharp as they should be. But I shouldn't have been driving.
Thank you. Do you think she drank when she got home?
If she wanted to. I know we didn't play that.
When they leave the Waterfall Bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Alberts home, he didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher,
Nuh-uh.
Judd Welcher,
Hey.
took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess,
The liar.
you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did
Updated. He
is he
lied.
found a key, critical piece of this case that did not exist before. He found it recently, and it was that SD card. The SD card that everybody missed, including the defense
Nobody
expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the
That shit,
time
Welcher.
and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data, because John O'Keefe has a cell phone. And I said it in the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his
He
movements.
moved 83 feet.
And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical.
It is.
And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship, and then there's a trigger. There is a trigger on the way because they're lost, and when John O'Keefe calls Jen McCabe for directions, Jen McCabe says something that triggers what's going to happen next.
We don't believe Jen and Hank.
Slide 4, please.
Very close to the Alberts. In fact, when Jen was navigating John to the Alberts when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that just a little, please. And it shows you with the healthcare data, it registers as flights climb, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you could move down, please, Ms. Gilman. And then the bottom left, that's 34 Fairview. You can see, second by second, the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a three-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a three-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the three-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. There's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there, they're together. The data matches up perfectly, perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for two reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They fall behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it. Because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage.
And they didn't see
Not just
him
because they
in the
didn't see
car
it.
either, Hank.
They didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Ms. Nagel said they're there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe.
It's 12:32.
And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on.
And no one is
And then you see
there.
the data. John O'Keefe begins to move.
No one was in there.
12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves for 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high frequency data because waves are shut off. Now it's more random, it's low frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly where John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole. But that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves for 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says.
Yes,
It
it
doesn't
is.
say that he goes straight line and he walks over to the door. In fact, could he even get to the door from 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this fantasy
He
that
did.
somehow he walked
He
in
said
the
he
garage,
didn't
even though
have
there's
it.
no evidence, there's no witness, there's no data.
Okay. Does Snake have
20
evidence I don't know about?
Seconds of his life.
Thank
and
you,
he moves.
Lindsay.
And healthcare data registers his steps. It could be pacing. It could be a straight line. It could be
Pacing?
shaking the phone. We don't know.
Shaking
We
the
don't know. We don't
phone.
know everything. We don't know every little detail and every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds he's moving. And in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, John McCabe.
Don't call her his friend.
And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on.
What?
He's separate from her. He's safe. And then she makes a decision.
What?
That's what this case is about.
Hey.
Then
Hey.
she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day.
She just hit the man.
Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse.
And the man has no injury.
Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple of things so when you think about what happens next, you can really assess the facts of this case with the charges against Miss Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Miss Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove and what we have proven from the evidence in this case of second-degree murder is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes,
I'm sorry, did y'all hear him say heading back towards John O'Keefe? He did not say hit John O'Keefe.
did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him.
What?
At over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy.
Please don't.
If somebody, maybe a teenager, someone young, impulsive, is on a bridge, and they see cars going by, and they have a boulder, and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody.
Yeah, you
but they
are.
throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge, and it comes down and lands on the car, and there's somebody, passenger, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing the rock.
Yes, the hell you
Did they
did.
have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge,
What is
there's
going
a plain and
on?
strong likelihood
What
of death.
awful.
When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him.
Not
And
pointing
then
at
hit
his
him.
mama.
And he died.
Get Peg ass out of there.
I suggest to you that is second-degree
I'm sick of it.
murder.
Peg should have been told to control her damn.
The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not,
Thank you for
I submit
it.
to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left.
It is safe.
We know from the text stream data that you drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers the 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after.
It's too
It
many.
could have been 4 seconds after.
Too many it could have
But
been.
it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window
Really,
coming
it's
back.
just too much.
So even if it's a couple
think it's
seconds
rich.
later, 4 seconds later, whatever Mr. DeSorgo wants, he stops moving. John O'Keefe stops moving. Forever. Forever. Could I have slide 6, please? You'll get to see this more closely, and you can't probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred for somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed, can't be attacked. ARCA, they did some crash test dummies. You know what else they do?
Thank you for the super
Texturing data.
chat. Nothing like that.
There's nothing about that data that is uncertain. Nothing. Take that down, please. When Miss Reed hits John O'Keefe, collides with John O'Keefe. We don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back.
Y'all don't know
We
shit.
know there's a collision. There's no doubt there's a collision.
Yes,
because
there
the
is.
camera's all over the yard. It's all over the yard. And when he falls back, and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight.
Not in the
yard.
street, but in the yard.
Oh, yeah, it's called
Make
the
it make
blue field.
sense.
And you've seen videos. You can't replicate the exact contact. You can't, because you need where the person was hit, how fast the person was going, but you know what happened, because when you look at the debris field, when a light is broken, it's no different than what was on the front yard.
Why
It's no
wasn't it
different.
in the street, Hank?
She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails.
Whoever asked about the
Slide 7,
voicemails,
please.
here you go. I can't remember who said, are they going to play the voicemails? Here you go.
Healthcare starts at
Bam.
12/31/56, 12/32/04 to 12/32/12 is the data which is adjusted when you reconcile the clocks in Alexis. 12/32/09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12/32/16 is his last steps. Mr. Disorder says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change.
In the same window. Bye, Hank.
If we could have slide 10, please. Could you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car.
Hank, how he get in the yard? That's all I want to know. How
Now,
do you feel like
as John
he get in the
O'Keefe
yard?
sadly lays on the ground, abandoned, you're gonna have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're gonna have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2, don't need to prove it for OUI manslaughter, but for the 3rd charge, Commonwealth has to prove beyond a reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness, there was a guide, and that eyewitness tells us that she knew, and that eyewitness is Karen Reed herself. She tells you that she knew.
Please play the
We have
clip where
slide 8,
she's
please.
Please, thank you. Play the clip where she's questioning it.
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo, and I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come out and maybe trip or bend over to pick up his cell phone, and I ran over his foot, and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
she's questioning it, Hank. Did I, Mary?
When she left
Did I?
Fairview and left John behind, she didn't think he was mortally wounded. But she knew she hit him. She knew she'd hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please.
Why would she call him 53 times if she did?
Can you play voicemail 1, please?
Yep, here they go.
The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whippin's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe went in the house, absurd. 66 turns to 61, it's 12:53. 48 unanswered calls from the defendant. He's not in at a party, he's not wrestling with Brian Higgins, he's not in a fight. If he's in a fight, his cell phone would be moving. There would be healthcare data, there'd be steps. If he got into the house in 20 seconds, and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps because his phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm dealing with a fucking kid. Nobody knows what the fuck you want. Fucking pervert.
Carrie is down, baby.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows.
Why would he point that out?
She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked. Because she knows she hit him. I'm not suggesting she meant to kill him. Or for him to die. But she knows she hit him. And now he's not responding. And she's getting nervous. And she's getting anxious. And she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting. She could have fallen asleep. But she doesn't move for a while. But she wakes up. She wakes up early the next morning. You can take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, "Where's John?" She doesn't call Brian Higgins, has his number, has been texting with him. "Hey, was John at our party with you? Did you see John tonight?" She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. "Call Jen McCabe. Call Jen McCabe." Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? "When did he leave the house? What happened last night?" No. She calls and says, "I left him at the waterfall. I left him at the waterfall." See, now it's gone from panicked to self-preservation.
Oh.
"I left him at the waterfall." And Jen says, "Left him at the waterfall? He saw you in front of the house."
Jen agreed at first, hey.
Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, "Carrie, Carrie, Carrie.
Oh, he sounds so stupid.
John's dead.
Say it
I
right.
think he got hit by a plow."
You sound stupid. Say it right.
Why do you think she chose those words?
Say it right.
Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus
You can't even scream right.
for another big vehicle.
You can't even freaking
I
scream
think he
right.
got hit by a plow. And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever
I
wanted.
didn't see the super chat.
A worse nightmare to get a call like that. For what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night in a blizzard out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom with a perfectly normal life gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts, separately at that time, answers the call, gets out of bed, drives to go help, because they have a common denominator, a common bond, John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing, no taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken, because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are. You take a look, you'll be able to slow it down. You'll see the exact same piece is missing, because it's back at Fairview. That's why it's missing. It's not there, it's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35? 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Kerry Roberts comes, take charge kind of person. She pulls him behind, she sees the broken taillight in Jen McCabe's driveway, and she decides she's gonna commandeer this. We're going to back to Meadows, you're gonna follow me, leave the car, I'll drive. At this point, Jen and Kerry don't know each other. They've only met once. And they go back to Meadows, they obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Kerry Roberts, Jen McCabe, they're looking out the window, they can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview, and this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop, let me out." And they look around and they say, "What? Let me out, let me out." She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone, so you probably heard this before.
Exactly.
John looked like a buffalo on the prairie. It was just a lawn and a heap that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe?
Well, what's the name said a blob?
She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him, you're gonna see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. But remember
Why
that.
do you keep bringing
Piece of
up
glass,
stuff?
pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy.
No.
That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert House. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her glass. He took the glass. She says it. So the Albert House, they don't need to get the glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a Cellbrite record is not the same as a call detail record. There is no evidence, it was a conversation, no lights go on, there's no conspiracy. You can call somebody, it can ring, it can go to voicemail. They have no evidence, none, that there was a conversation between Jen McCabe, the person who was ripped out of her sleep to come help,
What?
and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McCabe see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this.
They could have said no.
When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time has anybody said, what time did he leave? I thought he went in there. Not even a whisper of it because it
Because they already
never,
talked about it.
ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Could we have
Why wasn't
slide
he
14,
on the
please?
road though?
You
Not
can
yet,
see
today.
there's Kerry Roberts' vehicle, and then on the left, you can see where they're working. Right up.
And then they show the other picture. I don't get why.
That is a trip, a stumble, and a fall. And remember when Bellamy fell, there wasn't snow. It was just the beginning of a dusting. It was the cold, hard ground. And remember what Dr. Isaac Wolf told us about cold, hard ground? Causes this type of injury all the time.
He said drunk
All the
people
time.
too. He said drunk people too.
If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8, 10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind.
What?
To memorialize what happened to him that night. Remember the straw I asked you to take a look at that picture? We're leaving the waterfall at 12:12, the black straw in the green
No.
on the street. Collision, glass, nose, straw, back, hits his head. Could you play the clip on the left, please? 59.
No, he just said.
So when John got out of the car at Brian Albert's house, he took my full bottle of soda, which is sitting in the cup holder.
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like perched on his nose, like just wedged like a splinter would be. And it just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders. These people are heroes. Some of them, you heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics, getting to work 2 hours early in the middle of the blizzard so that you're there on time.
One
so
person
you can help
said
people.
that shit.
These
Nuttall.
are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody. But to him, it's another human being. This is his passion. Katie McLaughlin, first responder.
Liar.
This is not just a profession, it's her
She's
life.
a liar.
Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with it, so she has to bring people with her to face it, and now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him, could I hit him, perhaps I hit him, that was earlier. Now, she's recognizing what she did. I hit him.
So he does
And these people are
say,
making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar,
you're looking at the man
or a
behind her.
perjurer, or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done?
Where's the evidence, Hank?
I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile
bring
with
him up.
no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is, you have independent, core people who hear her say, I hit him. I hit him. And the attempt is to portray everybody as a liar. But you don't have to rely just on these good people, although you should. You should.
They're liars.
You don't have to.
What
Because
else?
we have a guide, and it's Karen Reed. Slide 17.
Y'all, not they making Karen Reed the focus of the closing. He is their guide.
Did I always said I hit him, but did I really say it as many times as law enforcement's claiming I said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself. She hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Miss McLaughlin hear exactly that.
What was Flamati? He didn't bring him up. He was out there. Why
And Jen
didn't he bring
McCabe?
Flamati?
When she's sitting next to or standing next to Miss McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her on the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing.
What happened?
And the funny thing, the ironic thing is, you will see in a photo when Miss McLaughlin, the firefighter, was speaking to the defendant, Miss McCabe was next to her. Miss McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things.
It seems like it,
The
Eric.
villain of this story was trying to help the defendant from incriminating herself. The irony. Could we have slide 9, please? This is the battery temperature. You're going to have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data. The 29, 12, 13, they're leaving the waterfall, 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it's starting to go down, 72, 12:45, 66, 12:53, 61. And you see it drop and steady off at 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And his blood's still warm, either way, under him. Doesn't move again until 6:06. It drops down 7 degrees because the woman are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Terry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next reading, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the vote is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of a yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? And not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in the cold. And there's Miss McCabe in her winter jacket, soccer mom, trying to help. She has MS, her hands aren't working, she's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for a friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp,
Thank you, Redhead.
it's at the time it's open, and she's in bed at 2:27 looking up Hockomock sports because she is so interested in the kids' sports, and that timestamp stays open.
Hey, nobody.
And she goes to that tab the next morning when she puts in
Nobody believes it.
how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen
Crazy.
5 minutes to do
Liar.
a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over
liar
time.
too.
You usually can't delete that information.
She's a liar too.
That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased.
Hey,
But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27, look the other way. Don't look at what she did.
probably not Kira.
Former Trooper Proctor, look the other way. Don't look at her. Every time they make those, oh, she got the glass from inside the Alberts, maybe in the basement. Look the other way. Don't look the other way. Look at the
They
facts.
just want them to look
Look
at
at the
everything.
data, and it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction.
Why didn't they bring him
Disgust.
up?
Not saying you shouldn't be disgusted by the text messages. You should. You
Yeah,
should. They're
what
not
you think?
defensible. I don't stand here and defend impropriety. I
Then
don't.
what are you saying?
But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't get a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper McKennick was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't. But that does not change. It doesn't create a conspiracy. Doesn't invent a dog. It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. but it has nothing to do with the justice
Has
in this
everything
case.
to
It
do
just
with
doesn't.
it.
There's not
Everything.
one piece of evidence, not one, that we can look at and say, this was tampered with,
What?
this was planted, this was distorted.
Oh,
Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case.
why?
We don't need Trooper Proctor to
Why?
take this case beyond a reasonable doubt.
Shit.
That's why I didn't introduce that evidence to you.
Hang down on the phone.
Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house inadvertently, they didn't even know it, the dash
Why
cam
would they go to the
captured
house?
the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He hasn't been near the car. And in the Dighton videos themselves, when you close it, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please?
It's just too much doubt, Hank. I'm sorry. You gotta let this one go.
507. You can play any angle you want, but if you look at this angle, it's gone.
It's too much doubt, baby. Let
You
it
don't
go.
plant it. It's already gone. You know where it is? 34 Fairview Road, on the Reedfield. January 29, 2022, 823. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing when you do the videos, it's a different angle, a little smaller, but if you play that and watch the let's go up and down and slow it down, you'll see it expands. It's gone.
Yes,
So when you
Dad.
have Dighton Officer Barrows come in here and try to tell you what he saw in the salad port, couldn't have been it. You gotta ask yourself,
He
what
didn't even go
interest
to
does he
the
have
salad
coming in
port.
here in this case?
He didn't even go to the salad
A lot
port.
of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face?
Hell
He
no.
never said this before.
Not
In
like
fact, he
oh,
testified to the opposite. And so he sits on the stand with a new story after a meeting, we don't know why, but then I show him that bottom right photo with the snow, with it missing, and I say, is this the way it looked? That's of course before the snow melts out in the salad port so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman, there's no plant, there's no Higgins at the salad port, there's no one tearing out pieces. In fact, remember I played you a clip and you'll have it where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Kerry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it.
Thank you.
Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here, on her profile, but she can't explain the methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, then it's I don't know. And then when you look at each of the different parts of the abrasions, She says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it.
She's been looking at
And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. Laposada comes in and she sees punctures everywhere. It's an animal attack. It's a dog.
They all say it's an animal attack, though.
No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously, there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now
They all say animal dog bites. That's all I can say. I'll take it.
the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2
Hey,
years.
please
She knows
hang it
nothing
up.
about the data, nothing about the black box,
She could have mean
nothing
it.
about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very
Not
common
after
in
90
car
days
collisions.
either.
But that doesn't mean it didn't happen because she, in 90 days, saw a fraction of the information. A fraction.
She saw the
We
body.
know now, argument back and forth for days about lower body injuries. The suggestion is a car accident can affect everybody differently depending on the angle, the scope,
Hey,
the
shut
speed.
up.
Some people can get plowed over by a car, have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test, that you can have a collision with no lower body injuries. They did that for us.
With a dummy, hey?
And so the idea that at the time, in 90 days, that she doesn't have enough information to say consistent with a car accident doesn't mean there was no car accident.
That lady
Let me talk a
said she
little bit
could've
about
committed it.
ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, it's objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text
You
messages?
seen it a year later, hey?
What expert, what objective expert uses Signal, an encrypted app, to communicate about the case? Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all, and because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic.
We know.
It's basic. And he fought
I
me
don't know science.
over and over again. Did he seem objective that he was trying to help you? Because Dr. Renshaw came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. Do you adjust it? And he tried to talk to me like I was making something up. His own colleague had to admit it.
What are you
Now, it's
doing?
funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point.
What?
And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brendan asks you a question, make sure you ask for a transcript.
That's not
And
talking
keep the
about the
progress.
case.
Slow down the questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some.
This is crazy.
And so what happens with Dr. Renshaw, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. And he said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal, just ask him about it.
He had a ham
And he
sandwich.
says, I have a sandwich and I stand in the corner until I remind him that we got video footage
He
from
still,
the documentarian.
he still had a sandwich
He's in
in
one of the
the
scenes.
corner.
And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judd Welcher said this and that. It doesn't make it so. Judd Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was.
Then what was he
He was
doing?
trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judd
What the
Welcher,
hell is Hank?
Dr. Welcher, never suggested that. And his work on text stream data, unassailable.
What is Hank?
And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have
You don't
a
know
good
how
idea
it
from the
happened.
physical evidence, and we know that it happened.
Why does he keep saying
Can
that?
someone have a collision without lower body injuries? Could I have slide 19, please?
At 24 miles an hour?
You bet they can.
I know the hell he is not putting on a dummy. And then
We
playing
don't
the
know if this is
slow-mo
body
version,
position.
y'all.
We don't know if this is the exact speed, but what it
Y'all,
tells us,
he's playing, he playing the
This is
slow
violent.
version.
look at the debris field, look at his turn.
Hey,
Remember his
dummy.
sneaker on that curb that got lodged against the sneaker. Mr. O'Keefe then falls back, hits his head, counter coup, left to die.
Why the hell would he use a dummy? This is just
Thank you.
ignorant. Did he end? Y'all, he did not end right there.
Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult. There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Strengths, it is a plain and strong likelihood of death. You would never back down your driveway if your kids were at the end of the driveway. You'd say, what, are you going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't even have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please?
Now this is
He is not an it.
now
John
this
O'Keefe is
is
not
sick.
a body.
This is sick.
John O'Keefe is not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
Y'all, did Hank just end?
Thank you. All right, jurors, the next up is my instructions to you on the law. I'm not going to do that right now. You've been sitting for a long time. So I do have to tell you, even though you've just heard the closing argument, you cannot discuss this case even with each other. All right, so we'll send you back for lunch. It's going to be a shorter lunch. My instructions are long, and we want you to be able to get this case to start deliberations today. So I'm going to send you back maybe about a half an hour. Is that enough time for you folks?
How you gonna ask me?
So we'll give you a half an hour for lunch, and then we'll come back. I'll give you my instructions on the law, and then the jurors will go out to deliberate. I know there are 18 of you. We seat only 12 deliberating jurors, so 6 of you are going to be alternates. I can just tell you that. You know the odds, right? And I can tell you it's Mr. McDermott's least favorite part of his job is smoking. So we'll do that this afternoon. Do not discuss this case. See you in about a half
Wait, switch. All right, jury.
All bullshit aside, what did y'all think of Hank's closing?
Okay.
I thought Hank did a terrible job, y'all. I did. He did. The only thing he wanted to do was attack Arca's character, who they were as people. He didn't even touch on the science.
Counsel, can I see you just a second?
Ash said 0 out of 10 do not recommend. Y'all, I don't know what the hell he was trying to do. I'm sorry. I really, really tried. I was really hoping he was gonna come in here and really, really convince me to take a second look at what we've listened to during trial. He didn't. It wasn't convincing. I think he sounded a little defeated, like he just already knew. He didn't have the passion. And let me point out a place where I really said, you know what, Hank doesn't give a damn anymore. And y'all probably gonna say I'm dramatic. Y'all gonna say, Melanie, you know you do a lot. I needed him to say, she calls Carrie Roberts, and you hear, Carrie. He didn't do that. Hank said, she calls Carrie Roberts, and we hear Carrie. I said, oh, he doesn't even want to like lean into it. How am I to believe you if like that was saying the names 3 times was so big? That's a big part of Jen's testimony, right? Like you don't want to lean into it. I said, oh, Hank I did, Key. I wanted him to stand firm in what he was saying. I wanted him to stand firm. He did not stand firm. In fact, I felt like he was just up there. And then I'm not gonna even spend time on Arca. Why not? Why wouldn't you spend time on Arca? Because in my mind, that's who you should have been trying to discredit. And if you pay attention to his closing, he at no point tried to discredit their science. That's a problem. That's a problem. That is a problem for me. If I'm on the jury, you didn't try to discredit it. You didn't talk about it. So in my mind, hell, you must agree with it. You must have agreed with it. You had to. It gave putting, damn, I missed it that quick. Okay, here it is. It gave putting a puzzle together with two, like he was trying to force something to fit. I don't like it. Sandwiches, phone calls. Oh, listen, this is really what happened. Jen is a soccer. He kept saying she's a soccer mom. I take issue with the fact that he couldn't get his facts straight in the case that he's been working on, that he's been paid damn near $1 million to come in here and prosecute. You can't get your facts straight. You can't get names right. I mean, I mess up names all the time, but I'm not getting paid almost $1 million to watch this case. You are prosecuting this case. You should know this case like the back of your damn hand. You don't. You don't. And that's an issue. It was it was an hour and 15 minutes. So it's the same time. Oh, my bad, y'all. I think we on lunch too. So it was the same time that AJ had too. But I just think it was so all over the place. AJ's flowed so well, right? It flowed really, really great. And I like that he kind of took us on a path. It was some sort of order to his. We did not get that with Hank. He is dumb for us. Thank you. We didn't get that with him. It didn't flow. It didn't flow at all. And that's a problem for me. I didn't like it. I didn't like it. I did not like Hank's closing. Oh, that's so nice. They got Bev some pillows over there on her seat. I like that. I want Karen to be able to read. Now here's the thing, guys. Now, if we are to get a verdict today, I need Karen to be on the front of those steps. And I want her to talk about how we were not only up against the prosecution, but we were up against the judge too. Like, I want her to talk about that. Please, let me see what, because I called her yesterday. Let me see what she's doing over there. I want her to talk about that. She might, y'all, it is lunchtime. Y'all know Miss J take a real lunch over there. I need an interview. I want them to be able to get that together. The after party at the waterfall. She said the after party at the waterfall. Karen needs to stay away from the waterfall. I'm sorry. Karen needs to stay away from the waterfall. Karen needs to stay away from C.F. McCarthy's. Hell, when this case is over, don't you take your ass back to Canton. Hell, I could see Karen now just getting a ticket for looking wrong. You know how sometimes, like, in all honesty, I didn't know that there was a law against, like, I forget what the law is called. Y'all remember Fantasia got sued when she was talking to that married man? And the girl from TikTok, Brene, is getting sued too. I don't remember the law. But you know how places have these really, really old laws that they really don't use anymore? Baby, I could see Karen just getting a ticket for one of these laws that, hell, somebody hadn't been prosecuted for in about 100 years. Stay away from Canton. There it is. Thank you, Shataka. Stay away from Canton. Because we would see Karen on the news with a mug shot. Baby, the trial would be something like, it wouldn't even be jaywalking. I just can't think of nothing crazy right now to say. But it would be something weird. Stay away. Stay away. Hey, friend.
Hey, y'all.
Hey, girl. What? Happy Friday.
Happy Friday to everybody but Key.
Don't do Key like that.
Happy Friday, y'all.
Hold up.
I had to put my wig on real quick.
Brianna, how you feeling about the closing?
I feel like AJ ate down. and he put like holes in every, like he just made it clear that they have no case, and you can't go off of feelings because they made you feel like she did it. No, like it's not guilty. It's too much doubt.
I loved AJ's closing. I felt like everything he felt like the Commonwealth would try to say or try to use, he was like,
Yeah.
Before you consider that, let's think about this.
I love Shady AJ though. Shady AJ, he threw so much shade today. I said
so
he
good.
had to get it off his chest. He had to
so
get it
good.
off his chest.
Oh, it was so good. It was so good. What you think about Hank?
Garbage. Trash. Trash. Try again tomorrow. Oops, can't. No, trash.
Oh, I just think it was
terrible.
It was all over the place. It was all over the place. Not only was it all over the place, he just seemed to refuse to talk about the science. He didn't want to talk, and that's a problem for me.
But I feel like that whole, what he said about like, don't look at Karen, look over there, is literally what y'all trying to say. Don't look at Higgins, don't look at the people in the house, look at Karen, because you have no evidence. And it really is like I don't know, he worse than love. Like he's on his knees, desperate. Desperate.
Brianna, you know that's one of my
desperate.
Say beg on her knees, begging.
Desperate.
Begging. Oh, redhead. Redhead, I think, okay. Let's play a game while Brianna up here and we'll talk about it. What are the things, because someone said, well, Turtle Boy said that as AJ was doing his closing, there was like a meter or some sort of demonstrative where every time there was something that was reasonable doubt, it would go to this board.
Mm-hmm.
So what are the things you guys thought were reasonable doubt as you listened to AJ and Hank? They might, Miss Pooh. I don't trust them.
Okay, I can't wait till you get fired. I feel like,
can I?
I really hate Key. I wish I can 86 up real quick.
Let me see what that back. Hold on, Brianna. I think they just leaving. I think they're just leaving for me.
You are muted.
Yeah, they just leaving.
Oh, okay.
They just leaving.
I definitely feel like, I don't know, he had a lot of good points, and I wish we could see like it was like a split screen where we can see that screen and AJ talk. But he had a lot of good points. I loved how he kept repeating with what's that lady name? The last lady.
Dr. Laposada.
Yeah, Dr. Laposada. I love how he kept repeating what she said of like he wasn't hit by a car. And honestly, when he said it the first time, I thought he was gonna end there because I was like, dang, he running out of time. But he kept going.
I thought he was too. Every time I was thinking like I wanted him to end with a bang. So he would say something like, there was no collision. There was no collision.
Mm-hmm.
I'm like, okay, he about to end. And then go, and then I'm like, okay, that's not the ending. Okay. But I'm gonna say this. Hank had to have the worst ending.
It wasn't, it didn't circle back. It didn't put it together. It just didn't make sense. He just kind of left it. Like, and I feel like at this point, I feel like it's in Hank's contract, they said all he got to do is make it to verdict day or make it to closing statements to get his full contract, because this what it gave. It gave me, I got my full money and I don't care no more. Because what I don't know what it was.
She said it's in his contract. Well, wait, like Hank is already mentioning football. So like the football contracts. If you get this, and this is going to be your bonus. Like, just make it here and you're good.
Yeah, you're good. Like, that's what he gave. He was like, I'm gonna talk about the facts in the case.
I didn't watch Lori Daybell, but I heard it was a crazy case talking about if Hank's closing was worse than hers, and he's an experienced lawyer. That's bad.
Did she represent herself?
Yes, she represented herself. That is it. Kayla, you better be careful at that grocery store. They gonna think you crazy now. I told y'all. He said, gotta see.
Literally, Ash, literally. That's what it gave.
Literally, when we started this case, I think there were attorneys who said that Hank was actually a really great attorney. And so I like seeing great lawyering, whether it's the prosecution or the defense. I'm always like up to see it, right? Hank has not lived up. Like there were some things that he did, and I would be like, okay, Hank. But overall, I just can't see it. That closing, like I love the lawyer said
Dragged it.
He said great lawyers adapt. Hank did not adapt.
No, I feel like the only thing, and I feel like I said it in the chat too, the only thing he planned was to use those clips. He winged everything else.
Yeah, he did. Hey T, and Brianna, it felt like that. At first, it was at one point, Brianna, I said, damn, does he have notes up there? Because I thought he was just going from the top of his head.
That's what I believe. He was going, like, literally whatever popped in his brain, it was just going to come out. It didn't make no sense. And then the fact that he called John their best friend, I wanted to be like, hey, no. You really dragged it. You dragged it.
How did you feel about him consistently using those damn kids?
I hated it. I hated it because, one, you are the reason they know exactly what happened to their dad. And then, two, you're trying to pull this like sympathy card about these kids. When you wouldn't ask a kid, like, what do you think about my marriage? Why would you ask a child that?
Brianna, because you grew up in Memphis. What your mama gonna say? Stay in the child's play. Not a grown folks' business.
They don't know the inner workings. They don't really know, or they're not really supposed to know everything. So the fact that you're trying to say, well, the child said that they was arguing. Kids see that parents argue all the time. It doesn't mean anything.
Not Hank, Lord. Brianna, Hank talked about, because I'm trying to say Brianna Hank. When Hank talked about her pounding on that door, I'm like, so they were together for about 3 years. 2 years, about 2 years. You want me to believe about this one isolated incident? This one isolated incident in their whole relationship. Like their whole relationship. This is what you have for me. This is what you have for me. Hey, you got to stop.
Yeah, like even the voicemails, I'm like, I would hate to crash out one day and my voicemails get leaked as evidence. That's insane.
Oh, I can just remember when I was in my early 20s, because I don't recall ever acting like this in my 30s. But in my early 20s, don't play my voicemails. What's her name? Karen didn't sound like she didn't play. She was going down.
I will say Hank ate on one part.
Which part?
When he said they was in a toxic relationship.
Oh, he did. Did you hear me? Like they were.
He ain't lying.
Toxic. But
very toxic.
How does the jury feel about him saying toxic relationship? And then he also pointed out Karen drunk a lot, John drunk a lot. And I'm over here talking about 2 drunk. I said 2 alkies.
Yeah. And you could have said Higgins drunk a lot. The other people, everybody else drunk a lot. Ash, you know what?
How does that help Hank's case? He pointed out that not only was Karen drinking a whole lot. John was drinking a whole lot. And then, how did y'all feel about him bringing up how John greeted Higgins versus that ending when they were leaving? How did that make you feel? Like, what if you're on the jury, you don't know anything about this case? What are you thinking if you see, dang, he was so happy to see him when he got there, and then he looked like he had an issue when it was time to leave? What are you thinking if you're on the jury?
I feel like if they went in that exact order, using AJ, letting AJ go first, AJ broke that down so good. It was like he could have been a voiceover for the TV show. Like, it was the way he was talking. Them was like, oh, you see him, gesturing, and he pulls away, and they try to calm him down. He pulls away again. He's like, let's go outside. Like, the way he broke that down, I said, oh, that's exactly what happened. Like, I 100% believe that's exactly what happened.
I believe that at some point Brian Higgins got upset with AJ. I
With John.
can't. I mean, damn. With John, y'all see what I'm saying? With John, thank you, Brianna. With John, at some point, there was an issue.
It was the kiss on the forehead.
You think it was the kiss on the forehead?
I think words were exchanged prior. John went and kissed her on the forehead, and it pissed him off.
Okay, let's ask this. Do any of you, by any chance, believe John actually saw Karen kiss Brian when he came to their house? Do any of y'all actually believe that? Or do you believe or do you all think that he knew Higgins was trying to talk to Karen at some point? Do y'all think so?
Do we think that John knew that Higgins was trying to talk to Karen?
Mm-hmm.
Yeah, I think he found it. I feel like, honestly, they're so toxic. I really feel like Karen told him.
You think so?
I feel like Karen was like, I can go get another police officer. I can go get another man. He in my messages now.
Yes, I put the link in. When Merch just commented, I was like, Merch, come on up.
Yes,
Merch. Yates, I'm putting it up there. There you go. Yates, why you ain't say something? I put the link in earlier. Brianna just always the one that'll come up and chit chat with me.
They won't let me quit, so
no, you can't quit, friend.
I gotta come back. I do think that Karen told him though.
Lexi said, yeah, he saw. Lexi said, yes, he saw. And I'm gonna tell you why I feel like he did. Okay, period. Yes,
Hello.
Good morning.
Good morning.
Afternoon. I'm sorry, because
whatever time it is.
What did La Posada say? Still morning. We got about.
It's about 7 minutes to afternoon.
Oh.
Good afternoon. What's up?
Wow. About to go into the office. I worked from home this morning so that I could watch.
Oh, I love it. Smart.
Yeah. So I'm about to go into the office now that it is lunch, or almost done with lunch. So I did miss the last 10-15 minutes of Hank's closing.
Hank's closing?
Yeah.
Oh, child, you didn't
miss better.
Y'all are gonna hate me for saying this. Oh, thank you. I don't always look like a bum. Sometimes my clients do see me look like an actual attorney.
Y'all, the fact that she said y'all gonna hate me for saying this, it's like she finna holler out, I loved Hank's closing. Is that what you
No.
No. You can just say it.
I liked Jackson's more. Do I think that Brennan had some moments where I was like, okay, that's exactly what I thought you were going to argue. And that's how I thought you were going to argue it.
That's different. May, that's different from saying you liked it though.
I didn't love his closing.
That's you predicting it.
Yeah.
Merch, if you can hear me, I don't know if you can do that on YouTube. I'm gonna put you up, but I don't know.
I'm not gonna pull a Hallie, but I will tell you when. Again, a broken clock is right twice a day. Okay, sometimes they do say some things that I'm like, okay, that wasn't a bad argument.
Yeah.
I'm not mad at that. I'm not mad at that.
So there were portions of his closing that I was like, okay, all right, not the whole thing by any means.
So tell me which portions, if you can remember.
Definitely was not the beginning. The beginning was
shit
horrendously slow, and I was like,
I hated there was one person that could have helped John that night. Karen Bree. I thought that was
honestly, that's one of the parts that I liked.
I hated it, but okay. Tell me, why did you like that when there was more than one person who could have done it?
Because he basically was saying, and again, no one yell at me because I like Jackson's better, okay?
Well, you don't have, listen, Yates, I want to make it clear for people watching, we are not mad at people, or we're not like having an issue with people like believing Karen did it. It's the fact that,
well, I'm not even saying that.
No, or like differences of opinion. It's the fact that just be able to back your opinion up. That's all we're saying. It can't just be like Chupa Paul.
So she's the only one that did it. My thought process was, okay, he's trying to say that she knew that he was hit, and she would have been the one to call 911 right when it happened to get him immediate help and could have actually saved him. Because for people who believe that
makes sense, yeah.
That makes sense. He's saying, okay, if you believe that she was the one that hit him and knows that she may have bumped him or figured it out 5 minutes down the road, then she would have been the one to call 911, get him immediate help, and she would have been the one to save his life. Whether or not she stayed anonymous or said who she was, she could have called to say, hey, someone just got hit right here, click, and then hung up and still had medical aid rendered to him early on instead of hypothermia setting in.
But it didn't set in.
There are people, okay, I'm telling you, there is going to be at least one juror who believes that. I'm sorry.
He said, I like what Yates is saying, agree, but I take issue because then he goes to it was 33 minutes. He started bringing up time. And so like in that time, if he was out there, I just felt like when I heard it, it really felt like he was putting everything on her as if he wasn't allegedly in a front yard with all of these people moving about the house. Jen coming back and forth to the front door. Them being behind, like that was my only thing with it. I get what you're saying, but testimony literally contradicts what he's saying,
and he's not gonna argue that though. Yeah. That's the thing is he's not going to make the points that Alan Jackson did.
Of course,
but he should have at least talked about the collision more if that's what he's focusing on. Like he really just tried to debunk witnesses is what it sounded like. It didn't really. Yeah. He didn't really focus on the collision much. If you're going to say that she should have helped him and rendered aid after, then let's talk about the collision. When did it happen? How did it happen? Like,
well, I have a question about that, Yates, specifically for you, Yates. How do you feel about Hank and like the way that he worded, oh, well, Aperture, this is not really the reason that Aperture did this test. And they were just simply showing that this is kind of what would have to happen. How did you feel he argued that point? I don't know if you saw that portion.
Was that in the end of his closing?
It may have been in the end. Yeah.
It may have been.
I'm gonna, when I get off work this afternoon, because I should be off around like 4:30. I am going to go back and watch.
Yeah.
One point that I think he made well was the How Long to Die. I liked that he made that very concise and basically said, if you believe that she was up at 2 a.m. searching kids' sports stuff, then you have to believe the later How Long to Die text.
Why?
Because their whole theory, and I'm saying, if you believe that, if you believe she was up at 2:27 searching kids' sports stuff, then that theory of, okay, when you pull up that same, what do they call it? Like when you have a bunch of tabs open on your phone, like I do,
but
when you bring up again, this is
You
if you
gotta
believe this, if you believe the state's experts. If you believe the state's experts, then that makes sense.
Dang, merch.
I just need Apple to please come up, because for me, Yates, and I don't work for Apple. I don't do any of that. It just does not make sense that I could have a tab open and hours later open this same tab and it won't track it. It just does not make sense. If
And
you
it doesn't make sense to
20
me
years
either.
ago, 20 years ago, I'd be like, damn. But in 2022,
No.
It doesn't make a ton of sense to me either, but I'm just saying, if you follow their logic and their theory,
I don't trust
then that's how they're making it add up.
It don't add. It does, because their theory also, listen, wait. Their theory also, and if I'm the jury, I'm looking at this. When you look at that chart Ian Whiffen presented, it was entered in like 2 or 3 different ways. So if the one at 220, the one at 227, and the one at 6, they were entered in 2 totally different ways. So how do we explain that? I just can't believe it. And plus, Ian Whiffen changed. I don't believe Ian Whiffen, and I definitely don't believe Jessica Hyde. And I hate that, because I just want them to stay to the science. Jessica Hyde, she seems so passionate about her work. But the fact that you went from multiple sources to figure, to find something out, to now you only use Celebrite, just one source, I can't trust you no more.
Yeah. And that's going to be one of the things that the jurors get to consider, because they get to pick who they believe and how much they believe them.
Yeah.
And like, there's certain states' witnesses that I could be like, I don't like you, but okay. But like Dever, I don't like her at all. I don't believe her for 1 second. I don't trust her. I think she probably did see that, and I think now she has changed her testimony. She is one that I fully believe that.
What about the Emmy? Let's look to the ones that have to deal with science. What about the Emmy?
And again, if I haven't seen enough of it, I'm not going to speak on it.
I like the Emmy. And to me, she was one of the witnesses I can respect, because she stuck to her science, what she believed. Even when she said, damn, it could have been caused by the Lucas machine. Didn't think about that. But you're absolutely right. Would it have changed you? She said, I'm going to stick by what I did. Because she looked at everything. She didn't consider that.
And the thing about her, at least from what I remember, she didn't change really between defense and the Commonwealth.
She did not.
And to me, that holds a lot of weight with me, whether it's a Commonwealth witness or a defense witness. If you hold your own and stick to what you did between both, and you don't get combative with one, unless they're getting combative with you. Yeah. That's fine. I understand if someone's getting combative with you, I understand kind of getting an attitude.
Dr. Richler.
I was just about to say Richler.
All the shits.
But and I didn't see him. I've seen clips of him, but I didn't see his.
You gotta
he was with all the shits.
And he was so calm. Like, he answered every question.
He was laughing.
Yeah, he was.
I did see some clips about when he said wasn't, and I think Hank Brennan said, was it or wasn't it? And he's like, well, I just answered you. And he's like, no, you didn't. And he's like, wasn't. I'll speak slower. Was that Rentschler or Rentschler? Okay. So I've seen a little clip, like bits and pieces on TikTok, but I didn't see his full testimony by any means.
It looks like it's frozen. I was just adding you up. Looks like it's frozen.
Did the defense's motion, so Bev is not going to address the holes in the sweatshirt again? Or is she going to do that during?
I don't know.
That I don't know. I don't know that she needs to. The way that Alan Jackson brought that up in his closing, I think it was very well done.
Yeah.
Agreed.
Me and Stara and Hallie all agreed that, like, Jackson's closing, the first 5 minutes, and I just posted my one and only TikTok about this case, about my comments on closing.
Oh, let me go see.
But it is literally just me yapping about how it's insignificant. But Alan Jackson, the way that he started off the first 5 minutes, no notes. I mean, 10 out of 10, started off out of the gate incredibly strong. And I think that's why when Brennan got up,
What?
and sometimes prosecutors in general, they want to make it seem like they care, but it's just like, he was a good man, Savannah.
Yeah, he didn't have any kids. He didn't have nobody else.
And I'm
They
like,
didn't come across that way because you guys have not acted like he was such a good man, like he was loved, he was this, he was that. It didn't come off that way.
and so I think that just the way that he started, I was kind of like, okay, you didn't capture me from the beginning. And I just think he should have started off a little bit stronger. Because he could have absolutely started off with, there was a collision, and like had something that was a little bit stronger.
He couldn't, Yates. You know why? The opening and the closing focused on John, because I really do think, just like we said, he knows his case is shit. I have a big issue with him not.
I don't know. I think he truly believes it.
I have a big issue with him not sticking with the science. And then, like, you pay Judson Welcher $400K, and then you don't even, now you want us to believe that the case had no value, it had no purpose. What did he do it for?
That's what really just threw me off. It's like he was just like, oh, well, we were just trying to show that it can happen. It was like, but you showed nothing.
Nothing.
You showed nothing. Like AJ said, literally, it was I said third grade. AJ said kindergarten. It was literally like a kindergarten project. It was so insignificant. Like it made no sense to me. And then the fact that you want to compare Aperture's testing to ARCA's testing.
I said, it's the hill you want to die on, Hank. Is this the hill you want? What do you say, ARCA? I won't spend much time with them. I know you won't. But what did you guys think about him using the slow-mo version of a crash test dummy and saying, we'll show you what happens when you hit there's nothing wrong with the lower extremities? Like, what, Hank? It's a crash test dummy. What are we doing here? I thought that I didn't like it.
I didn't like how I really didn't like when Hank was trying to retell or recount his version of his cross with Rechler.
Oh,
and like and he really thought he ate him up, and he didn't. Like, oh, well, I asked him about a sandwich, and it turns out it was a camera crew there, but you didn't show us.
And he did deny it.
Tell us.
And I'm saying this again, y'all. I really wanted Hanks. Like, I just expected more from him. And even if he wasn't going to really stick on the science, I just really wanted him to hit his points better. The one thing I do feel like Hank did do a good job with in his closing is proving that she had a lot of drinks. We know she had a lot of drinks, right? So we do. But here we go again. AJ talked about those drinks because he knew they'd address it. No, not a person who got on that stand testified that she was drunk. Not even Jen. No one testified that they spoke to her that night and she appeared to be drunk. Let's not say she was drunk. She didn't appear. She moved her car. I thought we go back to those damn clips. Her in these interviews, hearing her. I mean, I just don't think it helps for her to say the drinks were weak, so I added shots.
Yeah. And so I do think one point that he made, one was her saying that, but also that I don't have to show that she was drunk. I have to show that it was less safe for her to operate a vehicle.
Yeah.
Which is very true for is it OWI in Massachusetts?
Yeah.
So I do think he made a good point there. He was like, I don't have to prove she was drunk. Cool. You don't have to find she was drunk. But her saying that I added all of these shots, those are her own words, and then saying anyone who's had that many shots, it's probably less safe for them to operate a vehicle.
Oh, yeah, I'm looking for my notebook because y'all know it's time for us to start. They're about to go through the charges, and we've got to see what elements have to be proven. And as we know, with two of those charges, they can, if you have to prove all of the elements. You can't, and the problem is it's always those last two. It's always for me the last two elements with under the charges. They can prove she was drunk. Them talking about she went to the hospital the next day and she was 3 times over the limit. My only issue with that is, well, where was she at the time of the collision? We don't know.
Yeah.
Does that matter? Does that matter, Yates?
To some extent, yes. How long was it from the time of the accident until she was in the hospital?
Probably 7 to 8 hours.
I do think that matters because, again, you may have a juror or multiple jurors who are like, hell, she was distraught. Why wouldn't she keep drinking?
Yeah.
Why wouldn't she do that?
That would be my thinking. Like,
so I mean, that is not unreasonable. It's not unreasonable for a juror to think that at all. But it's also not unreasonable for a juror to think she's tiny. She's tiny and added all these shots. But
they
again,
also said something about her
colostomy bag.
No,
but again, if you can believe both, that's reasonable doubt, and that is what Alan Jackson hit on beautifully in his closing. He hit on that, I mean, beautifully.
Mm-hmm.
The way that he described beyond a moral certainty.
Mm-hmm.
I mean, again, I was like, no one can take away, whether you like Alan Jackson or not, and again, there are people who do not like him, but you cannot take away the fact that he did a phenomenal job. And again, there were things, you cannot take away the fact that Brennan is also a very smart attorney. Whether you liked how he handled this case, he's not a dumb attorney. He made some dumb things in this case.
But what do you think people are going to take? What do you think is probably going to be like the top 2 things people are going to take from like either one? Because I feel like I don't even know if I have that many from Hank's, but I have a lot of things that, even though AJ went first, when Hank was talking, I still was remembering about AJ.
Yeah.
Mm-hmm. And that's very I think it's going to depend on how the jurors have felt about them throughout the trial.
I want to know, do they?
Because I think if one person is like, I have disliked Brennan this whole time, they're not going to be swayed by necessarily his closing. But if they've been kind of neutral between it, they might be like, I really clocked in for Alan Jackson's closing because he really captivated me.
He was. Oh my God. It was just like his voice, his attention to detail, the way that he makes sure that you can understand what he's saying. It was, I mean, the attention, like I felt like, I know he was looking at the jury, but like he was just really pulling you in, his eyes. Yeah. Even when Hank was up there, he was looking at the jury, like he was so attentive. Yeah. Hank just doing this all day just gets on my nerves. He just, his voice annoys me.
Not Hank. AJ could really teach like a public speaking class because the pace of the way that he talks, his tone, when to inflect, when he doesn't, it's really masterful to listen to him. Like he can really teach a public speaking class.
And that's, I think, and thank you to that comment. I appreciate it. I think Alan Jackson, not only did it have a flow, it was a timeline. And I think one thing that Hank could have done much better, because I don't think he did it well at all.
He did not.
Was jumping. You can say it once or twice in a closing. But when you say, we'll get to that in a minute, 6 and 7 times, that pisses me off because I'm like, holy fuck, just tell me. Give me something. That irked me and that may just be a pet peeve of mine, but I didn't like that because you can use it once or twice because I understand sometimes you're having your thoughts are going. So I understand you may do that once or twice, but doing it so many times, it makes it seem like you don't necessarily know where you're going next. And that thought just popped in, and you're like, we'll get to that in a minute.
We'll think about me. It makes it sound like Hank was me on a random live. Okay. Hank was
Me
me
trying to make a video, it's like, all right, we'll circle back. And then I either don't end up circling back, or I lose that point, or the jury was ready to listen to that in that moment.
Yes.
And then you go back to something else.
Yeah. It was
so
that, let me see. It was that part, Yates, and it was also him consistently saying, we don't know when this happened. We don't know what time. And I'm like, this is not good, Hank. Stop saying that. Or it could have been right here. It could have been here. Could have been, like, terms like that bothered me so much, because I do believe that's exactly what the defense is saying. They do not know. They are assuming all of this stuff. And Hank just kept throughout his closing, he just kept saying, could have happened here. It could have been this time. He could have done this. He could have had this. Like, it was too many could haves. And I felt like you really, really made me lean more towards reasonable doubt, because you kept talking about the data, but you would follow right up with could have. We think this is, and that was a problem for me. I think he should have stayed away from words like that.
And I think, to play devil's advocate, even though the devil doesn't need an advocate, I think, again, and because I've been listening to some people who, because I want to know what people who are very free can read, I want to know what they're thinking, because I am dead set on this being a hung jury.
You think a lot of people feel like that?
I think it's going to be a hung jury. I do.
But do you think a hung jury is fair?
Huh?
Wait a minute. So let me ask this, because that's not a clear question. When you say you think it's going to be a hung jury, are you basing that off of, like, the evidence that has been presented to you, or are you basing it kind of off of what you think the jury may be thinking, based on it? Like, this has nothing to do with you, but what the jury might be thinking.
I think a little bit of both.
Okay.
Because I do think if there is a juror who believes that the timeline has never changed, which is what the prosecution is arguing, that the timeline has never changed. If there's one juror who believes that, then that's going to be a hung jury. because again, they're putting that timeline up to a collision. And I think, and again, my fear is always that, like, there's going to be that one juror, because that's all you need. You just need one.
Yeah.
And jurors, I don't know. If they believe that, then they could say, okay, maybe she didn't intend to hit him, but she backed up and he's laying there in the middle of the street. Cool. Okay.
Do you think that one jury is so far?
Prove that.
Do you think the one jury is so probably, like, really believing the Commonwealth's theory that they can't be convinced by the other jurors? Or do you think it's a possibility that, like, okay, they may go in and it may be a hung for a few rounds of voting, and then they could possibly change?
I mean, that's very possible. I think that's possible in any case. There's always the possibility that you have one person who's like, I'm not changing anything. But then it's always a chance that someone could change their mind.
That's just my issue with the hung jury thing is, from watching the case, if it's a hung jury, it's literally because your personal feelings are in here. They have not proved a collision. Where have we seen they prove the collision? That's all I want to know. Where in the evidence?
This point,
believe that lady was drunk all day. Where? Give me one piece of evidence from the Commonwealth's case in chief that shows there was a collision, because I think that's the essence of the case, the collision. What piece of evidence do we have?
If you believe the broken taillight came directly from hitting him, and there are absolutely people who believe that.
But Yates, and then to those people, my question would be, because I was asking when Hank was talking, I kept saying, why wasn't the taillight in the street? Why was it 8 to 10 feet away? We've seen the pictures, we've seen the demonstrations. If I go break my light outside of my house, the glass falls there. How did it get 8 to 10 feet away? Y'all like, and this maybe I heard Star got a anti-Karen Reed live going on. I need to join because I want someone to tell me, how did the tail light, I was out yesterday. How did the tail light get 8, 10 feet away?
And I will say, Star, because I have been in the comments listening, because I'm like, I do want to know what people think.
Yes.
And she does push against them a lot on like defense stuff.
No, what you've been in their lives. I haven't had the opportunity to. If you've been in the lives, what do they make of this evidence?
They rely heavily on the taillight and the like black box information and basically the car data, the aperture.
Say no more, Yates. Say no more. You said aperture. I'm done. We can move on. You said aperture. I'm done.
And
to me, it's like
aperture.
The taillight pieces that were recovered, what, 6 months? I mean, a month to like how long after?
But why is there no DNA on taillight pieces that they're alleging scratched this man's arm up? Also, when you reconstruct the taillight, you're missing pieces. Which
I'm not saying what Star believes because that's
that's not what we're asking.
And it's other people's lives. She does not start alive, but I'm not saying what anyone believes. I do think it will probably be a hung jury. So I'll say what I am predicting.
No blood, like nothing on the taillight pieces. I keep saying yesterday I was out to eat, so I couldn't join the live. But it's just like aperture.
And again, for me, if I was a juror, I would vote not guilty because for me, there is reasonable doubt.
And that's the only thing I'm concerned about. I feel like people who go, she's guilty, it's really a personal thing. Like, and that's fine, but that's not how our law works. When we get to our law, like you said, it has to be, if there's reasonable doubt, you have to vote not guilty. And I think AJ did such a great job explaining that to the jury.
He did. Again, the way he explained, that's why I was like, his first 5 minutes, I was staring at my TV and I was like, please keep talking. Like, in the way that he described that, I was like, there's no way that again, as a juror, I would vote not guilty because for me, there is reasonable doubt.
And that's it. I just wish we could stick right there, Yates. I just wish people, even if you feel like she's guilty personally, is there reasonable doubt? And if you tell me no, then I'm going to say, okay, you're full of shit.
I love how he talked about, like, there's no level of reasonable doubt either. Like, it's like, there's either reasonable doubt or there's not reasonable doubt.
Yes, like I just thought he did such a great job. And they fight me all the time on Twitter, all the time on X. It's always people in the comments like just talking about it. But I just for me, it's like if they would just, do you think there's reasonable doubt? Reasonable doubt? Oh, okay, then let's stop. We don't have to argue. We don't have to talk about it. Like, is there reasonable doubt? Yes, y'all. AJ looked damn good in that suit. That suit, it definitely gave. Man, high-powered defense attorney, okay? That suit looked expensive. It looked good on AJ. That man's hair was, I'm talking, he must have used, I can see him in there now just getting that hair combed just right. He looked good. I'm sorry. He looked good. He looked good, baby. He looked good. See, they're going to be deliberating soon. I hope you got y'all notebooks out, though, because after they send them away, we need to talk about the elements in each one of the different offenses that she can be charged. Is it called offenses? Am I saying that correct?
I don't know. They're typically called offenses here, but I don't know what Massachusetts call calls them.
Because it is different. How did how did you feel about the defense going first with the openings? I mean, with the closing arguments?
Because so that happens here all the time. So they have the option to what I call clopen, so they can do the first closing and the last.
Okay.
They can sandwich it. They can split their time. So sometimes a prosecutor will do 15 minutes and then save the rest for after the defense.
Okay.
They don't have to. They can waive that first opening close and just go last. And I've seen it done both ways. I've seen prosecutors take the first 15 minutes and then do it. I feel like since they only had an hour 15 here, that's why he was like, I'm gonna waive my first opening, and just go after. Again, I don't love when people do that because I'm like, but they can do that. It's not uncommon. I see it all the time.
He probably needed time to recoup and split that. Like he probably should have split his closing, but Hilton did a split closing. That's what Hilton did, right? In YSL. So Hank should have split his clothes. He needed time to get his mind together because it was like he would get us to a point and then he'll say, but we'll come back to that. And then now I'm lost and I don't even care anymore.
But here's the thing. Do y'all think they brainstormed about his closing? I don't feel like it.
They don't give team vibes.
No. Did y'all see yesterday? Hank really did look up from that computer one time.
And I don't know if Lally and the other person are annoyed because he's a special prosecutor and is kind of coming into an area that they normally handle. I don't know if they have feelings about that. I don't know.
Okay, here's a question for you guys. How long do y'all think they will take to deliberate? Until the end of the day, Monday, Tuesday, or Wednesday?
She's only letting them deliberate for a couple hours until 5:30. So I don't see them necessarily having a verdict today. I don't.
I say Tuesday. I give it a few hours. A few days just in case like there is someone in there who just
Okay, hold on, y'all. I think they said they're back. Let's see. Ash, you my girl, because in my head I was thinking today. But I didn't want to be that person on here talking about today. Like, I'm just too excited, but.
All right, they're back. So I'm going to go to work and listen to this in the car.
See you later.
All right, bye, y'all.
It did 4 days last time. Thank you, Brianna. I heard you say bye this time, Brianna. I don't know where my notebook. I think I do know where it is. I need to get my note. I have a notebook right here because y'all know I got to.
No, Chris. Yes, I'm sorry.
Oh, Bev, shut it up. Y'all know when she said, I'm sorry. Y'all know that little movie that's out.
Please.
Okay.
One second.
Okay, y'all know this is going to be long. She's going to read the instructions. So I hope somebody else taking. Oh, I got a whole box of pens. Look at that. Amanda. Is that bird come in at 227? It's John. Okay. I got me a little notepad. I can write these instructions down. Well, it depends.
Okay, Paul.
Oh.
Rise to the jury.
Jim. Now you're gonna have to go through.
Forrest, I agree. It might be longer than 40 minutes.
Oh, okay. Okay.
Yates, nobody feels bad for your clients. Please stop it. Yates, go on with the dramatics. Nobody feels bad for your clients. Here's the thing: is as attorneys, you can have whatever personal feelings you need. That should be totally different when you become an attorney.
All right, jurors.
No.
Going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict. But before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal case. The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law. That's not necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case. However, I have no opinion about how you should decide this case. You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence. The arguments of the lawyers are not evidence. They are not witnesses. If a lawyer during argument made a mistake in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests. They're simply doing their job during the trial. There was testimony at trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence, and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits, are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But your job is to decide the case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involved factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training, and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that's sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case. Not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described. You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify, since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions.
Oh, okay. At least we do some of it.
Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now, I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has three sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these three prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death.
Intended.
If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well.
I'm sorry, y'all. It just doesn't even make sense.
In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or a highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way.
prove that.
Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely.
Oh shit, she
By
operated.
decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol. You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of whether the defendant operated a motor vehicle under the influence of alcohol, you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation. The defendant's rate of speed and manner of operation,
Don't know.
the defendant's physical condition, and how well the defendant could see and control her vehicle.
We don't know.
The condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all 5 elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another,
I get it, Lily.
the act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. The defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people.
I know that to be true.
A person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, I'm sorry, hold on.
See, don't mess up.
And the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence.
No.
To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI. So the third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle.
Oh, bye.
And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay. Thank you. All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter. In order for a jury to return a verdict, that is, to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury. And you will note that there are 18 of you.
Oh, y'all.
To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate.
Here we go.
Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, and in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case.
It's not 6.
Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right.
It's number 5.
So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right, so I skipped the line. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, as you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel at sidebar.
Okay, y'all. Miss Little needs to wear a hat. I can't take it today. It's too much. It is just too. Okay, guys. I'm trying. I am trying. Hey, Missy. I am trying, but Bev and this young lady really, really pushing it. I mean, not Bev. Damn, I can't get names right today. Peggy. Peggy. What's so okay? Let's go ahead. Missy says she thinks verdict watch will be 8 hours. How long do you all have? Y'all, Peggy's got to get it together. Ash, I don't know what's going on today. Does Peggy have her teeth in? It's crazy. Crazy.
May I?
Yes.
Could the juror sitting in seat number 13 step down and take your place as an alternate?
Oh, damn. Hold up.
Could the juror sitting in seat number 7 step down and take your place as an alternate?
Uh-oh.
Juror 6, could you step down and take your place as an alternate?
Oh, y'all didn't want sit. Y'all didn't want sit.
Juror 17, could you step down and take your place as an alternate?
Go ahead, 17 down on.
Juror 2, could you step down and take your place as an alternate?
Juror juror 2 was
And juror 8, could you step down and take your place as an alternate?
okay. Well, Turtle got most of the out.
All right. Yes, please do.
Could I have the court officers raise your right hands? Do you swear that you will keep this jury in alternates in some separate but convenient place until they agree, that you not suffer any person to speak to them and to speak to them yourselves, nor ask them if they agree, nor suffer them to disperse until they have discharged their verdict, except by further order of the court, so help you God? Thank you.
All right, so members of the jury, I need not remind you that you have an important responsibility, but I believe that you will bring to bear all the wisdom and the judgment and conscience that you possess in reaching your verdict in this case. All that we can expect from you is that you decide the case with integrity and with principle. We all expect you to reach an impartial verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in court during the trial. We are looking for impartial judgment dictated by your reasoning and the fullest discharge of your oaths as jurors. You may retire and deliberate your verdict.
Jurors, make sure you take your notebooks with you, please.
All right, y'all. We are officially on verdict watch. Have to go charge my phone. We are officially on verdict watch. Wow. 33 days.
I'm going to see counsel one more time.
Okay, y'all. Now we got to figure out what are we going to do on verdict watch. We can I mean, what I would suggest, we can watch some old testimony if y'all want to. I don't know if y'all want to go back to, I don't know what parts of the testimony. We could watch the stuff that I missed. You guys were watching that I missed. Because we gotta, Shanny, don't throw up. Don't throw up now. Please don't be out here throwing up. Let me get my phone. Let me see what Sue is talking about. What was yesterday? I didn't watch this. You mean the day before yesterday? You mean Retchler? Y'all want to watch Proctor? Yeah, the last 2 black jurors got kicked off. Okay, let's see. Let me see what Sue is talking about. Hold on, because I was on Turtle Boy's page. Okay, what is Sue talking about? She says 5 notebook juror, her science juror, the juror I think hires people, are among the alternates. 7 women, 5 men. 2 persistent note takers. The juror who I think draws, and expressly jurors are seated on the final 12. Oh, and the expressive juror. They are seated on the final 12. The juror I think draws is crazy. So there's she says my science juror. That may be good. That may be good. The juror I think hires people. I wonder why she says that. Hold on, let's see if she said anything. Said they paid a lot of attention to the charges and that information. So do you guys think I need to we can read the article. 5 notebooks. She said about she put money on them. Ash, I think so. I think the science juror is good. No, the notebook juror got picked. She says the 5 notebook juror, the science juror, the juror she thinks hires people, they are among. Damn, no. Sorry, y'all. Sorry. She said they are among the alternates. but 2 persistent note takers, a juror who she thinks draws, and an expressive juror are seated. The science juror is not there. The juror who took a lot of notes, gone. Took a lot of notes. Mel, I think Miss J tried calling you. Oh, I see it now.
Judge, the first thing is counsel this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150?
Yes, this is exhibit 155.
155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory's not perfect, but I believe that we were going to have this redacted, subject to the same redactions from last trial. I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe it was redacted last time, so if defense
Okay.
wants to make that redaction, it can go into evidence.
Great.
I'll see that Sharpie and maybe I can just take care of it.
I think we probably have one here you
I
can
have
have.
one. I definitely have one somewhere.
All right.
That's number one. And number two is, can counsel look at the verdicts and just tell me if verdict slips and just tell me if they're okay with it? Thanks.
You'll see that it's not what you provided me yesterday, Mr. Kennedy.
anticipated that.
Really, Nikki? I'm trying to sit up. I thought they were staying until 5, Shandy. They're looking at the verdict slips. Mikey, I thought they said 5 or 5:30. Oh yeah, they're gonna be here a little longer today, Shandy.
Oh, thanks. Oh, Jesus. You sworn in first. Counsel, you can keep doing that. Mr. Rose, can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place until they agree, and that you not suffer any person to speak to them, nor speak to them yourselves, nor ask them if they agree, nor suffer them to disperse them, then to charge their verdict, except by further order of the court, so help you God? Simply because you weren't in the room. Thank you.
Lizzie said she's gonna get up out of here. She said 5:30. You don't see it, Shalon?
Is the Commonwealth content with the verdict slip?
Commonwealth's content.
It doesn't look like the defense is. Bev don't pull no shit.
So, Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses.
What's wrong with it?
We really ran into the same issue last time. I think what complicates it is the fact that there are two theories for two of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for
guilty
convictions on this verdict slip. So
Okay.
we would again ask the court to adopt our proposed
Just
verdict.
put not
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Ms. Giannetti? I have not found any. I've looked.
There's not a lot of case law out there even to support this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
Not yet.
And I mean that
So
with all respect.
that's fine. So your rights are reserved. Does that help you?
Right, well, all we can do is object, Judge, and you make
Okay.
the decision.
Okay.
Judge, the last couple,
If you find authority for that, let me know.
We'll do.
Okay.
the last couple things, Judge, is that we were provided with a clean computer laptop. Thanks. With a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right. So we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
And then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
Thank
All
you.
right. Thank you.
All rise for the court, please.
I just don't see the harm in putting not guilty on the damn form. Like, what's the harm in doing it? Why, Merch, perfect question. Why would you not want to be clear? Why would you not want to be clear? All they're saying is, listen, Judge, there's seven guilties on here, one not guilty. Why can't we just be clear? For every not guilty, let's put a guilty on there. Like, why is this so hard? And she's talking about, did you find some case law? He said, shit, it ain't none to support this one either. Oh, just that it hasn't been objected to. He said, yeah, it hasn't found to, I think she said, has not been found to, I forgot the word she said. Anyway, the point is there's no case law on either. It's a freaking verdict slip. And she denied their motion today, the transparency motion. And then we have this. Then you guys are saying some of the jurors that you think could have helped the case, they were alternates.
There's no way that happened, but their ending was good. Recall, they being the prosecution, recalled to some of the things that the defense did. The most ridiculous thing I think they did was presented this whole thing about the possible dog bite. And they were able to kind of take that and say, there's no scientific way. This person that they got to testify about the dog bite never has. They don't know anything about dog bites. They don't know what they look like, what they smell like, etc. So that's a good last thought to say, hey, go back to your common sense. Go back to the evidence that we have. And here it is saying that she's guilty beyond a reasonable doubt.
But Joe, the fact that you were able to just articulate so well either side, isn't that reasonable doubt? Isn't the fact that we really don't know what happened and you could argue either one, isn't that enough theoretically to be reasonable doubt?
There's no doubt about it. And to be honest with you, if I had to pick a pony, I would say the defense is in pretty good shape here because it's just not as clear as it needs to. Sure, the prosecution had some things to say, but the defense, the idea that the chief investigator was not testifying at all this time means you make the whole case about him. That's what the defense was going to do. The prosecution tried to sideswipe it a little bit, and they did the best job that they could, but it's truly taking the lemon and making lemonade, because if you were so sure Proctor would be a central witness, not just somebody that's talked about centrally, but the jury doesn't get to hear from.
Yeah, it doesn't get to hear from. Huge in this case, in my opinion. All right, just in the last few seconds, does it make a difference to, darn it, I lost my train of thought. I had such a good question.
Baby, it's so clearly everybody got ADHD. Let me call Miss J back. That really just upset my nerves so bad. So bad. Why not just make the verdict slip clear in the attitude? Why does Bev have an attitude? Hold on. I hope I turn my phone up. Why would Bev have an attitude about this? I just don't get it. Can you hear me?
Yes, I can hear you.
Oh, okay. Now my phone's turning. Hey, friend!
Hey, friend, you look cute in the pink.
You know they told me to wear some pink, so I put a little pink on today.
Listen, I got on some damn pink pants.
You,
Okay,
we got the pink on today.
We got some pink on.
We got the pink going on today. They said, Mel, you need a drink today. I'm gonna definitely have a drink today, especially if we get a verdict. But how you feel about, since I just Bev in this last little, she wouldn't change that verdict slip.
Well, this thing right here where she like, well, you don't have case law to prove it. Well, it don't say it, ain't nothing out there to say I'm not accurate. I'm trying to figure out what is the big beef about having just as many not guilty
as
options.
guilty.
You have guilty options. If it's not guilty, then it's nothing. I don't mark this. I can see how somebody could get confused. And because you keep saying, well, they upheld me the last time. So what? You know it caused confusion the last time. So you're just going to stand on it because somebody had the nerve to question you?
I just have an issue with that because I don't get, you know what? At the end of the day, she said it on the stand. She told the jurors that it is her job and the juror's job to ensure that this defendant has a fair trial. And if her attorneys are saying, hey, judge, we're not saying make more not guilties than guilty. We're saying equal them out.
Equal amount.
What's the problem?
The same thing.
What's the problem?
Why do you want them to see the word?
Did you see the verdict slip?
No.
Okay, I'm going to send it to you so that you can kind of see.
My thing is like, why would you want, even at that point, just the sheer look of it, to see guilty, and not really see not guilty. That
psychologically, psychologically, it's not good.
Somebody, but there's one thing I can't let go of, friend. There's one thing I can't let go of. When Hank said his experts was out here getting real data, not making up dogs. Where did Chloe disappear to now? There ain't no dog.
Hank said a lot of craziness. That was one when he kept saying, now we can't tell you exactly when the collision happened, but we assume it had. I said, why would you put that in your closing?
Why would you get up here and get to talking about? Why would you get up here and get to Hank just get too far ahead of himself? He was naming off everything that had to do with them temperatures and accidentally named off that Carrie took it and warmed it up in her car. Like, hey,
he said he was going through the temperatures. This is what was ignorant to me. Why would he go play that video of that crash test dummy and say, I'm going to show you how you can have he said a collision and there be no injuries to the bottom of the body, to the lower extremities, and then proceeded to play a video of a crash test dummy in slow motion. I said, this, you know what? This man has lost his mind.
When she said, I really wasn't trying to embarrass him. I was just asking him why he used that dummy. Well, didn't your dummy use the dummy?
Didn't your dummy use the dummy? Why would you do that? Why would you do that?
He was so far gone, he said, thank you to Shannon Welcher.
I told you I wasn't crazy. That man said Shannon Welcher.
I knew it was going to be a bad day when that man got up there. I said, maybe he just decided to be quiet for a full 24 hours.
No.
Think, pray, and get himself together. But I knew it was going to be a bad day. He said, but before we get into the evidence, let's talk about the evidence. Why? Wait a minute. Where are we going with this? When he said that,
Hank said, Hank's, y'all, what did Hank start off with? I haven't forgot. What was the first thing?
This is Ashley's fault.
Oh, no, that's what he said. Thank you, T. He said,
the eulogy.
The one person in the world that could have saved, and he pointed towards Peg's direction. I don't know if y'all caught that. Save John O'Keefe. Was Karen Reed moved this? I said, oh hell no. This can't be what we're doing.
Started out, like that man ain't say, I bet he ain't gonna get up here and tell you that he lied and misrepresented this shit to you. He ain't gonna say nothing about it. And if he don't, it's a shame. That's exactly what I'm talking about. That man got up there and said, John O'Keefe was 46 years old. Don't give me no damn eulogy. And he just sat up there and called you out. Talk about what we talking about.
He had to.
Go to his funeral?
He had
I don't want to
to.
hear the eulogy.
He had to do that, T, because he can't. He did not bring up any science in his closing. He had to, and what I thought was, let me tell you, he couldn't even go out with a bang. A picture of John O'Keefe was the ending.
He went out. Listen, once he started saying, Kaylee told us.
Why would he bring them kids up? Why would he bring up some kids?
Why are you using them kids? You ain't used them kids this whole time.
Why would you bring up some kids? And then bring up an incident that we heard from Karen talking to Higgins that she thought he had cheated on her. So we're going to take the kid's word over this woman's word.
So you ain't got nothing to say about Peggy Higgins. You seen that wild boar turn into a javelina right there in that thing. You said they were just grappling.
I just couldn't believe what I was watching. No science at all. Science. I think that's a problem. How long do you think the jury's going to be gone?
Let me tell you something. I'd have walked out that door and turned around and came right back. I'm done.
Do you think it's going to be that fast?
To do, like, call Proctor the boogeyman. Said the dog. They made up a dog. And then said anybody that goes against them is a liar and a perjurer. You know that girl admitted to perjury and it had nothing to do with what you were talking about. Like, then it just showed that Hank will rob Peter to pay Paul.
Yep.
Like, it just showed that Hank will do whatever he wants to or thinks he needs to make it sound worse. That man called Proctor an infection. And then he sat up there and called him cancer.
He said that was tough. I said
that was tough. I said he ain't call him no cancer.
He talking about during the trial. During the trial.
But the thing is, they're not gonna remember.
Who gonna remember that?
An infection.
But here's the thing, though, T. What you have said, would you even have brought that up, knowing that the man was a cancer?
Well, my thing is this. How do you not bring it up? So now you try to justify not bringing it up because you said you don't need him.
He didn't need him because the evidence spoke for itself.
Without him? What could you have used without him?
What evidence is he talking about? He replaces having Proctor. What evidence? I mean, what evidence do you think is there?
Well, my thing is, you said that we should trust Buchanan because Buchanan didn't ever call Proctor honorable.
And I don't remember that. You tell me, T. Do you agree with that? Because it seemed like to me, Yuri, because I remember when he was on the stand, I said, "Oh hell!" I said, "I'm not going to believe Yuri because Yuri just said that this man was honorable." He said it.
Well, my thing is this. If he could say that he was not honorable, but the investigation still had integrity, if the investigation and you still had integrity, then there would be no reason why you couldn't say that those text messages were flirtatious. Why can't we admit everything if it does nothing to the integrity? You know good and well that you were just trying to cover your ass.
I think for Yuri, I didn't hear that. Then he started trying to bring Nuttall in this when, what was her name,
when
y'all?
He started trying to say that we have to believe the EMTs.
The heroes.
They are heroes.
They are heroes, babe. We have to believe them.
And then had the nerve, like, he just always got to put 20 on 10. Like, why can't you just stick to where we at? He always got to put 20 on 10. He goes from infection to cancer. He said, well, these EMTs are heroes. What you think? Just because she know Caitlin Albert at McLaughlin went the night before and planned the murder?
Here's the thing, T. The defense.
Did nobody say she went to go plan it? We saying she complied after she knew who it was.
But not only that, I don't remember AJ just like really trying to like drive that point in. Why would you bring that up again?
I don't remember AJ saying anything about tampering with or planting.
Nope.
Since they want to talk about planting evidence, he
didn't say that in his closing.
You said it.
Well, you remember he did that to Dr. Retchler. He said, "What do you think happened? Do you think people planted evidence? Tell us your theory." I said, "Damn, Hank, he didn't even say that." I said, "He didn't even say that." I said, "He didn't say that." Where are we going with this? Second charge is the problem. If you check guilty on top of them, then that opens up having to check a box for the lesser included. But far as my thing with this is why I like that Bev read everything out. You can't prove all of the pieces all of the prongs, as Bev called them, that you need for those charges. The blood alcohol level, we don't know what her blood alcohol level was when she was driving that car.
That's my other problem. I hate that he got up there and lied. Hank, we see that Hank will lie when the truth will do. Hank got up there and kept saying her blood alcohol. You didn't have it. You had the serum test.
You didn't have
her
it.
blood. You had the plasma test. Not saying it's bad, but you know that was a point of contention during it. So instead of recognizing that was a point of contention and honing in why that test is just as good, you just lied and said you had the test that they was talking about all along.
8 hours later. 8 hours later. Let's not 8 to 9 hours later.
And they're gonna say, "Well, I'm not supposed to talk about the credibility of another attorney's argument, but I'm just saying."
I said no. Hank was really. You could tell he wasn't confident in what he was saying. He wasn't confident.
All over the place, and right before the crash out, he bounces all over the place, and he was bouncing. And once he started bouncing, I said he's getting ready to crash, and he did. And when he put up that picture of John O'Keefe, talking about he wasn't a buffalo on the prairie.
Now, where did that come from?
From Karen, from the interview. She said that it was a lump in the snow. I said it on a couple of times. It was kind of like a buffalo on a prairie.
I didn't remember that.
John covered in all that snow in one of the clips.
Child. No, okay. I didn't remember her saying that. And I watched them. I just didn't remember that. There was no intent. And then, Sassy, there's that. There was no intent. And if she
was Ashley, you got me up here driving over here by your old girlfriend's house.
Now,
slam on the gas.
Hank did Hank convince you that Ashley is the reason she got so mad and ran him over?
Well, this is the thing. I would be inclined to buy every part of, I'll say this, even if I believed every part of Hank's theory, every part of it, I took all of it as facts. If you line everything up, it's kind of like that thing where somebody gives you a word and you got to find the words within the words, and every one you got that all match, you got to cross those out.
Mm-hmm.
Everything that you said that kind of goes against their theory or combats the other one's theory, let's cross it out. But see, if we cross everything out, comparing the two arguments, and I'm not saying one is more right than the other, I'm just saying, if he says there's a collision, he said there was no collision. Cross it out. I'm just saying, if you have something to combat it, let's cross them out. When we get to that end of that list, we have two things. We have the diffuser in that light, where the light ain't going to work if that's broke.
Yep.
And the light was working at 5:07 a.m., when the light can't work now because the diffuser is broke. So you have to tell me how that diffuser got broke, because it wasn't John if it happened at 12:30 and at 12:30 and at 5:07 you got a light
coming. Yep.
That you're showing. Both of you are showing this, and you have a light at 5:07. Remember, I said as a juror, the one thing you would have to show me to get me on your side is that tail light was already damaged before 5:07, before it contacted with a lay eye, before it hit John's car, that it was already damaged. And even if I believe that it was already damaged, I don't believe it was damaged to the point that you said.
No.
Which means that even if it hit John and then hit John's car, it still should not be in the condition it's in after meeting Proctor. That's a problem for me.
Yep.
And then after the diffusers, we also have the, if you are wrong, in the interest of justice, will you say you wrong?
And that's why I hope these people do.
He ain't gonna get up here and tell you what he did. And all three of them sat there and watched them do it. And when he said the Commonwealth created them holes, oh, that did something for me. That did something for him. Because technically they did, but I wasn't expecting them to say it like that.
Yeah.
But when he said that, and you could
that was good.
Say, you know what? Even in all my passion, even in knowing what I know, I can even be human and make mistakes. And I did not mean to mislead you. I saw
he
this.
Should have
I
said
saw
it.
that. I heard this. He said this, and in the heat of the moment, I said, well, the sweatshirts look alike. I should have stopped myself, regrouped, and taken a look. But I didn't know how much longer I would have that particular witness. And I said something that inadvertently, it was not to mislead you. It was to show this doctor who was, I just told y'all, was arguing with me about nothing. I was trying to catch him up. You could have sat there, put your tail between your legs, and been a man about what the fuck you did. And I would have been more inclined to believe that maybe they are lying about a dog. You know, whatever you came up with. But the fact that I knew that Hank was going to be pissy. We know he has tantrum.
We knew it.
We know he has tantrums. I knew he was going to be pissy the moment AJ said 8 damn weeks and they ain't say shit about a dog.
Nothing.
When he said that, now there's never been anything. Hank, you even brought up the fact that Chloe is now Cara.
They did. AJ was dropping bombs.
Old ass dog, a new name, and then you get in your closing argument and say, my ex-person has to make up a dog. Make up a dog? You done told us about the new dog.
Not only that, we know the witnesses were asked, so we know for a fact whether you believe that dog did it. We know that the dog was not made up. These people owned a dog.
And the dog ain't there. So to say a made up dog, I said, you know what?
Well, I think he was just kind of spiraling because
he was spiraling. We know he starts to crash.
He was crashing, T. I mean, it was just kind of hard to watch because Mia just said he was off script the whole time. Mia, this is what I was going to say. I said, I know he was off script, and I know every time he looked down at his notes, he was like, oh, damn, I missed that. Because he was off script. They said Chloe now identifies as Cora.
Not identifies as. Because we know good and well that he begins to spiral. And when he begins to spiral, he starts to jump and ping pong and leapfrog all over the place. And he tries to tie it together. And it just never truly happens that way. It never does. So I think that I think Hank is figured because he just started to spiral and spiral in this way. He wasn't this bad. And I said the other day was so bad that even though I don't agree with his antics, I would never want to watch somebody professionally spiral like that on the World Wide Web where they can't come back from it. It's just hard to watch. Whether I like Hanky Pank or not, it was just kind of hard.
Especially for his reputation.
Because you will still be an attorney after Karen Reed. Why would you ever waste your time, let your degree go down the toilet on this? Like, why is this where you want to? You don't even do this for real.
I think for me, I said, for Hank, you want to keep your dignity, right? Whether it goes good or bad, keep your dignity. Say you did everything. That stunt he pulled with that jacket, that stunt right there, I just wouldn't trust him. I think he showed the type of person he will be to win a case. The DNA evidence about the dog DNA evidence, I thought that was nasty. I do believe the defense, and not just because I love the defense. They worked really hard to work within the bounds of the law. They know Bev been on some bullshit, but they've been taking it. What did Nettie just say? Bev said, are you saying it's not the law? He said, no, I'm not saying it's not the law, but I'm just saying that, I think ours was better if you could reconsider it. She asked another question. He was like, what am I going to do? If it's your rules, then we have no choice but to go with it. All I can do is object. We just have to go with it. They have worked. Even Lally, we can talk about Lally, but Lally too tried to work within the bounds of the law. Hank has proven that he will step outside the bounds to win the case.
Well, I think the other thing that Hank did, unfortunately, and I'm gonna tell you why I think Hank is spiraling. Because at first I thought he was just like so mentally involved and enthralled in this that he wasn't about to take an L. But truthfully, I think Hank just found out the truth, friend.
What truth?
The truth that this his fault. No, I'm serious. It's gonna be his fault. Because think about it. They didn't leave this on Lolly. I will, Cynthia. I'm about to. They tell me to eat.
Oh yeah, I told them. Wait a minute.
Lolly. I'm not gonna blame this on the Commonwealth, but think about it. If this goes to shit, it's the outsider's fault. Just like Karen is an outsider, Hank is an outsider. He really not in the club.
He's not. And you can tell. You can tell there's no collaborative effort at that table. There's for real.
Collaborative effort. He is just the face. And this is a savior. So when sugar go to shit, it's Hank's fault. Now, if Hank win, the Commonwealth won. But if they lose, if there's a not guilty, Hank lost.
I don't like
not
this.
Not the Commonwealth, not anything. You already know how this goes. You already know this ain't nothing. Just like he keep talking about it. He was a Monday morning quarterback. That's what exactly.
That was so funny. I said, "Oh, I'm so happy. I understand football now."
When he said that, it hit me so hard. Not because I knew what he was trying to say, but because Hank, you talking about yourself. Because if on a Friday night or on any given Sunday, that team win, the team won.
The team won.
But when they lose, that quarterback ain't shit. He need to be traded. We wasted our money. Why do we have him? Let me tell you something. Every time them Cowboys lose, Dak ain't shit. Okay?
Dak, I'm sorry, but even when they win, Dak still don't be shit. They hate Dak. Yes, they hate Dak, but I got you.
When they win, Dak still wasn't that good.
They don't like Dak, baby. They don't like Dak. I said, poor Dak. Dak got to be the most hated quarterback in the league.
Hank finna be Dak. If they win, the Commonwealth won. They gonna get out there, stand behind them, get on the steps. They gonna do everything they can. They gonna do all the interviews. Hank is gonna be Hail the Conquering Hero.
They said Aaron Rodgers.
Massachusetts gonna kick him out of there so quick. We never should have used him. He was never the right one. He really a defense attorney at heart.
And you can tell. Yes.
He did this on purpose. He's a Karen Reed friend. I heard he was talking to Turtle Boy. This man ain't gonna be able to do wrong right.
I don't want a mistrial either, y'all. I don't want one.
This needs to be over. This needs to be over. But I think Hank has figured out. Oh, Sonya, my son named Dallas. Okay, don't worry. My son named
Now they talking about Dak ain't shit. I'm sorry, y'all.
All right, now I'm a Cowboys fan. My child's name is Dallas. Let me tell you how big of a fan my husband is.
Oh.
He put that in the vows that I had to be a Cowboys
I really
fan.
feel sorry for the Cowboys fans because when I say y'all be spazzing out during the season, well, I mean, I'm pray for y'all.
I just think for sure that with no other reason, I think at some point after he rested, somebody let Hank know that he ain't in the club. Like he figured out he carried. There's a group chat with and without him. He's the carry there in the courthouse, and I think he's figuring it out.
I still because for the life.
Sure Hank said the same thing because I was wondering, like, as co-counsel, as somebody on your team, you know, you do a group project and somebody F up, the whole team gets the same grade. So why are y'all not stopping him when he's spiraling?
I'm trying to listen. They in the chat eating your Cowboys up. They say every season is their season. Somebody says Cowboys one sorry ass team and I don't even watch football. They gonna have to. I'm gonna tell you, Cowboys and Steelers fans are really different, and Saints and Saints and Falcons too. Because living in Atlanta, Lord,
it gets serious. But
Saints fans, the way they pray, I said, Lord, they be taking y'all pressure through.
Well, the Saints probably this sounds like they don't have a terrible season this year. It serves them right.
Jay said her dad was buried with a cowboy T-shirt and has a cowboy helmet on his grave. Listen,
on the grave.
Cradle to the grave. Cradle to the grave.
On the grave. Sorry, Shanny. I just said those fan bases are serious. I don't know about the other ones, but those.
Intimidate the jury. Turtle Boy said that. Said BKT was in there trying to intimidate the jury today, and the defense had to have security escort him to the DA's office. He better go on somewhere.
Damn them Saints. They skipped on Shador. Shador stuck. I would have been able to go to a game, okay, if they would have drafted Shador. Now he's stuck in Cleveland. It's just, ugh.
Listen, and I said I'm gonna have to change my wording about Cleveland, because even folks in Ohio are not normally Browns fans, and the only reference my grandfather ever said about the Browns is when he had to go to the restroom. He said, he always say, "Oh, I'm finna take the Browns to the Super Bowl."
Now that's messy. People seem to, y'all know I just started watching football. I've been watching for 2 years now, but I never had an NFL team. So the Browns are my team now because Shador's there. And I'm gonna be rooting for Jacksonville too, but Shador's my quarterback.
I know y'all don't laugh at my papa was mad.
Oh my!
That's what he used to say when his stomach would hurt. "Oh, I'll be back." I said, "Where you going?" "You take the Browns."
She said my laptop died, and when I come back, all I hear is y'all talking about them boys. That's Miss Jay's team. She was telling us.
That was in the vows.
Key,
honey.
Key. I keep seeing that Miami probably wants to trade for a quarterback, and this is what I've been praying for. Please get him out of Cleveland. I don't even like their colors. I don't even like the colors. Please get him out of there. Save us from these people. Get us out of there and let Cleveland just stink all year. You know what, Miss J? I pray that Shador is gone and we can take the Browns to the Super Bowl every day.
West Virginia,
No. Y'all really hate Jerry. I did buy the rookie card, but it's okay. It'll still be his rookie card.
Together a book of my pop-up sayings you burying 5 off top. Listen, I said I was gonna put one on the shirt, because let me tell you something. My grandfather had 3 levels. When we was doing something, somebody was talking stuff, and they were getting like Hank getting out of control. When he started his crash out, our grandfather would be like, "All right, now that's level 1 when you know you need to check yourself. Now, if you somehow missed the all right now, later on in that, when you starting to crash out, he'd be, that's enough of that. And if you didn't catch it then, and you kept going, and you just stood on the business you thought you were standing on, my grandfather look at you and say, okay, you want to get ignorant? I get ignorant right along with you." Now that meant the gloves come
wherever you want to do this.
That means you didn't F up.
That's what my mama say. Wherever you show out is where I show up. Jerry is the curse.
Haley, there is a side damn bar shirt. There is one. I think some folks should be getting this, hopefully. But there is a sidebar shirt. I think
Jerry don't know his name is Jerry. Missy, you're right. I didn't grow up watching football. I only started watching football 2 years ago. So I literally I try to, like, my team, I root for the teams that players that I like play for. So I'm getting Travis's jersey. We got Xavier Weaver with the Cardinals, so I'll be rooting for him. And who else? Of course, I'm gonna be looking at Jimmy with the Panthers. So I kind of look at the players, but the team I probably have the most for is wherever the quarterback is.
Listen, that's one. That's a new one. I'm gonna have to root for it. I'm sure hubby gave me somewhat permission at least to buy the boys' jerseys, because I told you my cousin, he got drafted to the Chargers.
No.
So we're gonna have to get one of his jerseys.
Okay.
I said, Lord, I'm gonna have to go to a game now. I had to go to a game.
Yes, go to a game. Purple Nick's talking about let's go Giants. I just saw something that said, y'all hate y'all quarterback. Y'all just drafted Purple Nick. I don't know what your Giants are going to do, but I'm not hearing good things about the Giants, friend. You might be on that boat with the Cowboys.
To come back too quick because I feel like Bev gonna call it corruption. I want them to take at least a day.
Oh shit. Hold up, y'all. She on here just talking. I meant to switch Miss J. Let me call her on my other phone. I meant to switch her to the other phone anyway. And I forgot. Let me see. I forgot to swap. This phone wasn't charging, and I forgot to swap her to my other phone. 7004. Okay. Okay, my bad. Y'all got Russell and Jameis, but that's not like a long-term fix. Yeah, she probably like, who the hell is this calling me? I don't even, is this number 404? Let me text her, tell her it's me. But yeah, I just root for whatever team they're on, but I make my main team, the team should do his own since he's the quarterback. So you can call me. Okay. Barchi, stop. I know one thing. The Saints fans got a fan base that hate their team. Yes, the Saints fans are really upset, especially after like what they did with their quarterback this year. I'd never heard of their quarterback before. And that doesn't mean he's not good. It's just like, I feel like if you're on X a lot, me and the way my algorithm is set up, I see all of these quarterbacks all the time, and I just never heard of him. So, sorry, Saints fans. I don't know what you guys are going to be doing this year, but I see y'all are having like QB issues too. And I don't want to get into my mess about the draft. But yeah, they having issues too. Okay, y'all. I'm trying to see because we're at Verdict Watch right now. Key, I saw some of the funniest shit I've ever seen on TikTok about that quarterback. I said, man, I kind of feel like that with Dylan Gabriel too. Even if people feel like Shador's the more talented quarterback, that's fine. But I just really hate how people just really drag these people down. I don't like that. Some people say today, Shani, because they have until 5:30. And then we have some people who feel like it'll be Monday or Tuesday. So I don't know. Washington say they coming every year. Yo! Oh, hold on. My phone on silent. She just called me back. Oh no, she was talking to me. No, is it my turn? I need to do it. Okay, y'all. While we're on here, I have to do something because y'all know we have wind down. Do y'all think we're gonna have a verdict for wind down? If we had a verdict for wind down, that would be so. Ooh, that would be so great. Give me just a second, y'all. So wind down will be like it looks like 2 hours after they leave if they're staying till 4:30. I hope it's a verdict. I really do. Why shouldn't we have a verdict? All right. What's your home team, Key? Do you guys think the jury instructions were confusing? Not for me, Don, but I also was taking notes during the instructions. So maybe that's why it wasn't confusing to me. But yeah. But that's just me. They weren't confusing for me. I think it was a lot. And if you really weren't paying attention, then maybe it could have, because it was long. It was they were long. I think she was up there about an hour. All the Packer. Oh, okay. Okay. I think so. So for me, I don't think it was confusing. I do think you needed to pay attention. And if it was just if you were letting like Bev just talk and zoning her out, maybe not taking notes throughout, then yes, I do get that, because it was a lot of information. It was a lot of information for you to just really take in at one time. And then she just went straight through. She went straight through. Sorry, Key. My bad. Phenomenal Mama, we're just on here kind of we're just talking about the verdict watch. Were they not taking notes again, Brianna? Did she stop the notes for I don't recall if she said that, but I went to go see like if they were going to get the instructions. It basically said it depends, that sometimes the judge will read the instructions out loud, and then they will also get some when they go back for deliberations. So yeah, so okay, so they were not able to take notes. So maybe that could have been confusing. That was a lot of information to take in without taking notes. Okay, thank you, Mia. There was I think we were talking about this in the chat. So they're saying Bev did say she would give the instructions, which I feel like is right. So that when they're back there, they'd be like, no, this says this. That was a lot. And if they weren't able to take notes, how do you ensure they are making the right decisions? How do you make sure that's what's going on? Okay, thank you. Karen saying just not doing closing statements. So I think that's fair. Hold on, I'm going to see. Jazz said I wouldn't need notes. Shani, I'm nervous too, but I think I'm nervous because of what Lexi said. Juries are unpredictable. And just because we feel a certain way doesn't mean the jury is going to feel the same way. Now, we all said not guilty for ASAP. He got the not guilty. We said it for YSL. He got the not guilty there. So it's just a little cute top. It's just a little cute top. Yes, we knew that, Sarah. I don't know how to feel about that. And especially after seeing that the transparency motion was denied. I don't know, but are they reasonable people, Key? We don't know. Black dude is going to be like, just to make sure I'm not tripping, do we need to write not guilty? Where does it go? I do feel like Bev letting her ego get involved, because one, they had the audacity to appeal this to the Supreme Court. And then the Supreme Court, I think, let me not say that. I think the Supreme Court should have really looked at it, and the fact that they upheld what she did, that's an issue. And now Bev is feeling like she can, feeling like she got a little chip on her shoulder. So I don't know that. Key, what? Aaron said they'll be given a proper copy. Honestly, if I were Karen, I would rather have a long, detailed instruction to avoid the same verdict form issue as the last time. The instructions don't bother me because we're not interpreting the law on a regular basis. So I do think it's good for Bev to cover everything. I was cool with that. Well, Sarah, people think exactly what you're saying. Only the Black people were chosen as alternates. You know, I'm gonna say this, and I do think that this is funny. This case, I have seen more comments than I can count for people saying, I hope there's a Black person on the jury. And I keep wondering why do people feel that way? Because I just, I feel like outside of race, you have to think about people's experiences, how they interpret things, who they are as people. But I have seen this a lot, so I know this has upset people. But in this case in particular, I have gotten more than enough comments on my page that say we need some Black people on the jury, and I'm like, why do people keep saying that? I don't. Ash, this is what I was getting at. Outside of race, people are people. I don't think it's a race thing. Shanny, I don't know. I don't think it's a race thing. I think people are people, but for some reason, like I said, on my page alone, I'm not just talking about TikTok, on X as well. I keep seeing that comment, and I say, well, what do they want? What do you expect Black people to do? Because there are tons of cases where that African Americans have been on, and they probably have not yielded the results that people wanted. Well, LaJoya, that's true. I just try not to think about that because I think race is such a touchy topic. But I still can't believe John O'Keefe was treated the way he was. Oh, now, Sarah, you got a point there. Sarah says, because Black people aren't taught to blindly trust the police. And if that's your point, then I just might agree with that. Okay. Y'all shut me up there. And y'all shut me up there. White people are less likely to believe the conspiracy case presented by the defense because we experience less betrayal of the criminal legal system and are raised to trust the police. I'm gonna let y'all have it. No, not a soul on my pages, on all of my social media pages, and I'm talking about Instagram, YouTube, Snapchat, TikTok, or X has ever expressed it in that manner, and then I can understand that. Okay, now I understand that. Now I understand that. Point taken. I got it. That, and I feel like, me personally, I'm sorry, and I tell you, and I don't. Maybe it's because from seeing what people have gone through, or what happened to me personally. I have been lied. I told y'all when I was like 18, I think I was 18 years old. I want to say 18 or 19. Like, the police were being really, really rude at we were at a talent show, and it was in Fraser. And they were being really rude to my sister. My mother just always taught us to, hey, can I have your badge number? I was going to give it to my mom and tell her what happened. And because I asked that question, he gave me a disorderly conduct charge. I had to go to court and everything. It was dismissed, but damn it, I had to go to court for that. I had to go to court for that. I was so scared because I'm like, oh my God, this is going to be on my record. So, me personally, I've seen firsthand the foolishness that can happen just because this person is in a position of authority. Amanda said, "Man, let me just say, I'm glad you're here because you got a story for everything. Not everything, but I think I'm 38 at this point. I grew up in the city of Memphis. You just about seen some crazy things. Shani, and the crazy part is, all I said was, can I have your badge number? So like I said, even though it was dismissed, I had to go to court for that. And when I got my job for those 3-letter people, they do extensive background checks. I had to, even though it was expunged from my record, I had to put that on my application, and I was pissed.
because it was some bullshit. No, my mother wasn't mad. She was at court. She wasn't mad. She wasn't mad at me about that because it was something she literally taught us to do. So it's something she taught us to do. I just think that I never, up until this conversation, I never looked at it. I thought it was what is the word? An injustice, but I never looked at it as like me having a run-in with the police and they did something wrong. Not wrong. I never looked at it as big as some of the things that we've seen when you think about African Americans and how they interact with the police. That's what I'm trying to say. So yeah. I didn't go to jail, y'all. I didn't go to jail. I didn't go to jail. They gave me like one of those little citation things. It's like they give it to you instead of going to jail. And then I think I just had a court date. Went to court. You talked to the little prosecutor person. They asked like what happened. My mom was there, my sister was there, and then it was over. So yeah. They said a criminal a criminal streaming crime. Full circle moment is crazy. It's crazy. Y'all know up until now, I'm telling you, I never really looked at it this way. Like it happened so long ago. I was 18 years old. That's like 20 years ago. The man had a PO. Who the hell had a PO? Hold on. Okay. But yeah, I never looked at it like that, but I get what you guys are saying now. I never looked at it when people kept making that statement. I never looked at it that way, but I'm gonna give it to y'all. I'm gonna give it to you. Wait a minute. I read that wrong, Ash. Wow. Okay. Mel, did you see the video of the Memphis officer chasing a man? Brianna, was it real? I saw like a screenshot of it, but I was telling Mariah, I said, this is probably fake. Was that real? I agree with that, Thelonious. Child, I agree with that. Hold on, y'all. I wanted to find. I really don't know. I don't want to see court TV, but I would like to see if they had some other stuff on. It was on the news, Brianna. Oh, I told Mariah, I said, this is probably AI. I said, this is probably AI. Well, Nene, I'm happy you're a changed person. Amen. Wait a minute, Amanda. She done called us some Amanda said real crime group. No. Missy, I didn't watch yesterday, and Keith said they didn't even stream the trial yesterday. So yeah. Wait, are we going to get to see who Forrest is? Forrest told me if I responded to his TikTok, then he would. I'm gonna have to send that to Mariah, but let me go to my messages. Let's see. Let me see how to. Hold on, y'all. Okay, let me check my messages, see if Forrest responded. Okay. Oh.
Hold on to. Wait a minute. Shani, when I got on TikTok, and it's probably because maybe we were searching something in my phone. But as soon as I got on TikTok, somebody is making a roasted broccoli bacon salad with hot honey mustard. And it has pecans in it. That was just the first thing that came on when I opened TikTok. I was like, what? Hold on, what Amanda say? Ken, that just doesn't sound good. It just doesn't sound good. And as soon as I open TikTok, that's the first thing. Well, Ken, you did tell us you was gonna be waiting on your friend in 2 years. You did. I worked there. I haven't worked there since 2021. But I got a lot of family that still works there. Thank you, Vitra. Vitra said they've been out an hour now. Ash, let's not mention the troll again. My nephew was talking about I think they were just talking to me last night about streaming. Oh, let me tell y'all this. Paper Plate said, what did he say he wanted to tell y'all? I was gonna go live, but it was loud. We were at Chili's for my nephew's birthday. He said he wanted to tell y'all something. But I do remember him making a comment. I'll have to get him on live. One of his comments said that y'all talking about him and his paper plate when some of y'all are probably getting dropped off at work in your car. They're saying till 5:30 today. It was something to that extent. And I said, oh, I have to make sure I tell them. I was going to go live because I said, oh no, you want to get messy like that? You need to tell them that yourself. I said, they don't eat you up. But I told him, you need to tell them that yourself. So he had a couple of comments to make, but I told him one day I'd go live. And I said, you can tell them yourself. Because I said, that's just too messy. I think he was just trying to allude to the fact that he's a good man. I don't know what it was. I gotta let him. I'm gonna have to. I told him to come on here and tell y'all that himself. Tell them. I said, tell them that yourself. Okay. Kiana, he was really bothered. He was. What time is it? Let me see. Baby, he was bothered. Y'all should have seen. Oh, I got his number in my new phone. Okay. Let me see. He definitely he might be still at work. Let me. Oh, you still working?
Nah, I'm at the car wash.
Oh, I was just telling my chat real quick how you said last night some of them get dropped off for work.
Yeah, they do.
You said what?
They be getting dropped off at work, calling me paper plate, but they unemployed boyfriend dropping them off every day at work. And I'm washing my car right now.
When you get to washing your car, they said they need to talk to you themselves. So I'm gonna go on TikTok and let you come on there.
Damn. All right.
They said, oh, they told me to tell you this rich chat gang over here. They don't know what you talking about.
All right, I'm gonna find out because somebody got offended and said, damn, he on to me. Somebody said he on to me.
Wait a minute, look, I'm gonna put you on here. What you say?
I said somebody heard that and said, damn, he on to me. It's all right. I'm gonna call you when I'm done.
Bye. He said somebody heard it and said he on to me. He was, y'all. I don't know why the paper plate bothered him so bad last night. And here go his sister. And you tell them it's nothing wrong with eating out of paper plate. Tell them his sister said that. I said, I'll make sure I tell them for you. That's how I tell him. I'm like, I said, now why my chat? I said, how my chat get in it? How did my chat get in this? I don't know. I don't know how my chat got in this. I work from home and my man has 3 cars. Come on, Vitra. I have 2 cars and my man is a supervisor for my city transportation company. Man, I'm gonna make sure he comes and read these. I'm gonna make sure he comes and read this. I don't know how we got it. I don't know how we got in it yesterday. But we did. Okay, y'all. Let me see if I can find. What are they talking? Let me see what they're talking about. I wonder what it looks like outside. Erica, I told him, I said, oh, you're going to have to come on live and say that yourself. What? Yeah, we're at 1 hour. Let me put it up here in case, even if we don't listen to it, I'll have it up so y'all can see. This is just Bev going over everything, but I want to know what the outside of the courthouse looks like. I want to know what that looks like. Y'all, I told him I was about to go live last night. Then I said, it was like I said, we were in the restaurant. I said, oh, you have to tell them that yourself. I just got off TikTok. It's packed. Let me see if I have TikTok on this phone. Oh shit, I'm calling somebody. I didn't mean to call him. Let's see. Hold on. She said, oh shit. Erica said, Mel, just look up. I'm definitely was in here. Y'all, I didn't see it. I'm down here looking at my phone, really trying to search, and it's on the screen. Baby, they are packed. They are packed out there. Oh my. I gotta make the screen bigger, y'all. So I can't see the comments right now. Girl, they camped out and they pink. Baby, I love it. I love it. Wait a minute. Y'all, they may not have a grill going, but child, they are out there camped out. Do y'all think, have they been out there all 33 days? She's not going to fix it, Candy. She is not going to fix it. Oh, Mira, put your little pink on, little cute pink shirt. Y'all, this is crazy. The amount of support that I've seen for Karen Reed has just been, man, it's been crazy. The crowd is bigger today. The Bev buffer zone ruined it this time. I don't know how these people get to sit out there all day. No, I don't know how they get to sit out there all day. I need somebody. I need boots on the ground interviewing these people. Where is that channel? Where is the boots on the ground? I want to hear what Canton has to say. Where is it? Miss Cherie, they are not. I'm trying to see what's going on X. I need, oh, I don't have X on this phone. I need to see the boots on the ground. They are there in, wow. Let me see. Let's see where Turtle Boy is. He was there. Now he might be live. Now, Court TV, if you really want to give us something, just start interviewing random people. That's if you really want to give us something. Interview some random. There we go. Hold on. Where is the Boston Miss Sylvia? That's a good question. Most are from the town or the county. They know the Alberts used to run that town. 90% believe Karen was framed. Sarah, I really do believe something happened. The investigation was really bad. Nothing really adds up. And because nothing adds up, you're just kind of forced to believe, okay, maybe there was a cover up. Maybe there was one. Okay, I'm trying to see if there's anything else. I don't really see anything down here. I'm trying to find something that's actually worth looking at. Turtle Boy says the mood outside is electric. Probably well over 1,000 people out there supporting Karen Reed. I took a picture with two of my former students from the Shepherd Hill class of 2011. I can't wait to celebrate with all of these fine people outside when Karen Reed is acquitted. Somebody right up under that tweet, y'all. Somebody said, I just called in to work today, taking a mental health day. Self-care is taking the day off work to watch closing arguments and hopefully a not guilty verdict. Today is like the Super Bowl for trials. What? Stephanie, you boots on the ground, girl. Stephanie, grab your bags, get back to the courthouse, grab you a pen, an ink pen. Use the ink pen as your microphone. I'm going to put you up on the screen. And I'm going to say, hey, Stephanie, can you hear me? And I need you to put your hand on your ear and say, hey, Mel, reporting live right now from outside of the courthouse. The mood is electric. There are people everywhere. There are people everywhere, Melanie, like this lady here. Ma'am, can I talk to you for a second? I need you to be the boots on the ground. Stephanie, get on down to the courthouse. Do we need to send you some lunch money? Get on down. Be boots on the ground. Okay? Get on. Go ahead, Stephanie. And make sure you do the ear thing, okay? It's got to look legit. Okay? It's got to look like a legitimate operation. Okay? And the only way it's going to look like a legitimate operation if you put your hand to your ear. and just start walking up on people, Stephanie. Okay? I need Stephanie to be out there with her pen. Or maybe we can go find you one on Amazon. Send it to you. Hello? I need you to be like, when they're asking questions, they're like, yeah, yes, Mel, you're absolutely correct. There are thousands of people out here today who seem to be all in support of Karen Reed. I have seen men in pink, okay? I have seen women. I've seen babies in pink, okay? I see pink baby bottles. The mood here seems to be they want a not guilty verdict, okay? They are chanting, free Karen Reed. There are signs galore out here. I need Stephanie, go ahead and start practicing, okay? Go ahead and start practicing, okay? Stephanie, you get out there and I want you to find that lady who had those red Solo Cup earrings. Find her. Tell her we want to talk to her. You got to start walking. And don't forget to be putting them. Yes. And what? Don't forget. Don't forget, baby. Listen, I need her to get Stephanie go get the word. Oh, you guys are saying the Young Jerks. Let me find it. I really thought y'all was trying to tell me it's a band outside performing. Sorry. I thought the Young Jerks was a band. Sarah, I thought the Young Jerks was a band. I thought y'all told me they had live entertainment for the people. I thought y'all were trying to tell me live entertainment was out there for the people. God damn. Oh, God. Okay. They are interviewing people. I really... I'm sorry. I thought it was a band. I thought it was a rock band out there playing music for the people. I just make sure I edit this out. Please. Yeah, I feel so bad. I really, really thought. I really, really thought.
If I get in the background there, looking through the soul of the
reward. Thank you.
Voted by the audience, right? That was...
I just like to say, I was really envisioning. There's sometimes a little rock man-ish outside of Kroger where I used to live at. And I just really thought, y'all, I could just see them out there now. A group of the Young Jerks sound like young kids. I thought it was kids out there with Vans on and skinny jeans, makeup all on their faces, entertaining the free Karen Reed supporters while they wait on the verdict.
Yeah.
Hi.
This guy? Vinny?
Vinny.
Hi,
Vinny. Hi, Vinny. Nice to meet you. You want a sticker? Can I give you a sticker? You want to grab some stickers, pass them out to people?
Yep. Want to give him a turtle?
Yeah, there you go.
Turtle, give me a turtle.
Oh, fucking heck.
Yeah, I know. Hear me out.
This is what I want. That's
Oh,
the
thank you.
there.
Maybe Clay.
Thank you. You got to pick one. Not the
Oh, but you pick one, a couple of them.
Do y'all remember that meme of that lady calling the police on somebody? Do y'all remember that? It was a meme of a lady. She sitting on the phone. She had on like a sweatshirt. She looked just like this lady right here sitting down.
Oh, thank you.
I know y'all know what I'm talking about.
Thank you. You got to pick one. Not the
Oh,
whole
but you
bag.
pick one, a couple of them. Couple, whatever you want. Not the whole bag, but a
Can I
few.
give one to my mom?
Yeah,
You
take a
y'all
few.
know who I'm talking about.
Take some different
I
ones.
know who I'm talking about.
Take the Young Jerks ones too. I'll show you.
Now, y'all
There's like 3 different types. Yeah, you get one of those. Take one of those. Take. You got to make sure you get one of these. Did they take all the other ones? Oh, no, they didn't. You You gotta get some of these. Grab those. And these, they want these. These are big ones. 3Ms.
I'm gonna give one to my grandma too.
And family.
Mom gets nothing.
No, you got something. When I get any.
Well, Mom, you got him sitting up
Well, all the young jerks are gone. They took them all. Thank you. Thank you.
Young jelly, but I just was thinking, oh, thank you. A little jelly.
No, I put it on my milkshake.
There you go. We got it. Thank you.
I'm going to just delete
Oh, nice.
out of this live stream. So
It's on your phone.
'cause I don't know who the jerks are, but the jerks, they playing. Let's see what Peter over there talking about.
How long it's going to take, what do we think is going to happen, and if a jury question comes out while we are live, we will play it, we will answer it, we will talk about it together. Make sure you guys hit that like button. Let's get to it.
And, Key, can one of y'all remind me to delete this out?
All right, Alan Jackson giving the closing argument for the defense. No surprise there. How different will it be than proving a conspiracy and that Karen Reed is innocent and sits there as someone who is framed, and the jury needs to determine that? Seemed like it was going to be more of a reasonable doubt argument this time, based on opening statement, based on the way a lot of the evidence was presented, but they did not fully abandon that Brian Higgins did this, that the cops maybe covered it up, that there is corruption there, and that there is somewhat of a conspiracy, although I believe that word was used more by Hank Brennan than it was by the defense team. Let's take a listen to Alan Jackson.
Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable.
If you remember when I talked about what I would do in my opening statement, a lot of it focused on the criminal justice system. So I love starting out with that and making sure they all understand what is reasonable doubt and how is it defined and did they prove it?
Operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true.
Okay, y'all about to scream at me for this, but I'm going to end this stream because I just feel bad. I don't want to take his views away because I'm over here streaming this, and I don't want no problems. I'm recalling a certain creator who was, I don't need no people. I don't need no problems with people and no streaming. He's watching this right now. He's really handsome. I'm going to end the stream so that if you'd like to go watch, you could go watch on his channel, because I don't mean to piss y'all off, but y'all know who I'm talking about. There was a certain streamer. They remember when court went out and we were streaming from that page. Maybe I don't know the right way to do it. I'm gonna cut it off because I just feel bad. I feel bad. I feel bad because I don't want it to be like I'm trying to take any
like streams away from his page. I remember that. I'm traumatized, okay? I am traumatized. Oh, yes, Khalees, I do. They did. They told us earlier. I don't think so, Lexi, but that certain creator really has traumatized me, okay? I don't want to I don't want it to appear like I'm trying to take something away. I don't want, like, I'm sitting here watching, I'm like, oh, wait a minute. I don't want I'm like, I don't want him to think that's what I'm doing. Do you really think all 268 of us will go to watch him if you leave? Yeah. Hold on, y'all. Oh, that was quick. Are you sure that's what it is? It says dental finger. Oh, that's what you're looking for. Okay. Okay. He said, sorry, y'all. Mariah was in here. We're not to do that. I definitely understand wanting to take precautions. I just don't want people to think that, you know? I just don't I don't want anyone to Barchi, stop. I was watching and I'm like, let's watch something else. I agree with that. Let's just see something else. And I'm not saying Peter would do that. I just if you guys don't know by now, this is probably a part. Like, I'm just trying to keep it honest. Do you want to do Jen? How about we do something from this go around? I miss the Sogra. I miss the cross of Dr. Wolf. I would love to see the cross of Dr. Wolf if you want to. Key, I swear. We are still trying to fight a copyright strike. Okay. Let's do. How about we watch the closing? What closing? T, we just watched closing. They're going back into the courtroom for what? Hold on, y'all. We gotta go on. Let's see what's going on.
Careless or mistaken act of the defendant or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result.
Okay, they're saying that they're going back into the courtroom. How did y'all hear that? I don't know, y'all, but how do y'all know they're going back into the courtroom? Can somebody tell me why you think they're going back into the courtroom? And who did y'all get that from? Damn, where my ex phone? Okay. I don't know. The girl with sunglasses. Does she have a name? The girl with sunglasses? Hold on. Hold on. You know what I mean by X key. Please stop. Please stop. They're going to go back in. So the young jerk. Oh, that's her name. That's her name. Oh, y'all, they are going back in. Well, wait a minute. Hold on, y'all. I'm online. Kathy Rustin I just shared Kathy Rustin. She gave, she put the blank verdict forms out. Where y'all get that from? Young Jock is crazy. Okay. Y'all, Sue posted. Today, Dedham I hope it's Dedham. Celebrates Flag Day tonight with the parade in the square. Although the judge indicated that today could go to 5:30, it's likely to end earlier. Somebody said, man, F that parade. Someone's life is on the line. And y'all done went silent. I'm trying to see how y'all said they going back in. Y'all, do y'all think that they look like they might be going back in? What the hell they running for? It looked like these people trying to get back in there. And if it's a verdict, I am done. Hold on, y'all. Oh, they still on there too, but I see a fan. What they saying?
Going to take a break. When we come back, of course, we were going to get you right back inside the courtroom. Stay tuned.
Karen Reed is in the midst of the retrial of the century.
She is factually innocent. She's guilty. There's something wrong in this county. Come at me.
The Karen Reed murder retrial. Live coverage today on Court TV.
Tonight on Closing Arguments, it's been the murder retrial of the century. We break down today's closing arguments as a jury will soon decide Karen Reed's fate.
Closing Arguments tonight at 8/7 Central, only on Court TV.
Hopefully a question. I hope it's a verdict because this is quick. Y'all, okay. This can't be, y'all. They said back in the courtroom. I'm gonna try law and crime too. What the hell? Girl, I know Pete over there like, goddamn. Okay, let's go. Barchie, please stop. Stop, Barchie. Yeah, I'm gonna switch to Court TV. I mean, Law and Crime, because at least they're in there. I see the fan again. So I'm gonna switch to Law and Crime. Anna, what the lawyer you know saying? The jury may have a question. I hope. Oh my God, y'all. They may have a question. He said Forrest outside the courtroom with his pink shirt on. Okay, y'all. 1 hour, 33 minutes. Let me see. Hold up, y'all. I'm sorry, y'all. I can't really talk. Oh, thank you, Angela. We are Shataka. I just created the link. It should be up. We are Shataka. Thank you for the super chat. We will be here at 7:30. Hell, if it's a not guilty verdict, I'm gonna have to talk to Miss JC. Do we start the party early? And if we start the party early, y'all, if it's a not guilty already, I'm gonna have to go ahead and run to the liquor store. Day, I'm trying to keep calm. This is nerve-wracking. This is nerve-wracking, okay? She said we don't get no verdict. Wind down, cancel. Child, this is nerve-wracking. Y'all, I need to see, did that man respond to me on TikTok? Because I definitely went off him. I said, you don't get out of my damn inbox talking about a smoke detector. You better. Chelsea, you think, I thought they say normally if it comes back fast, then you know it could be a not guilty. Oh, Amanda said, Amanda, that's a good point. Verdict clock is still going. So, okay. Oh, that would be a good point, Dave. They said they may have found some case law for that verdict form. I'm just saying, did they go back there and say, what's your verdict? Not guilty, not guilty, not guilty. Okay, then let's go back. But Amanda made a good point. It's still going. So the fact that it's still going right now, that speaks to there's no verdict. Maybe there's a question. I don't know. Me, I just got my 2 bottles. I know that's right, Miss Cherie. I have to run to the store. I'm gonna have to run to the store because, as you know, I haven't had any liquor in the house. So I'm just gonna get some wine though. Oh God. I mean, I just wonder if they took a poll and what are you feeling? What are you feeling? What are you feeling? Emily, if there is a verdict and we get on, I am gonna DoorDash. But if it's not a verdict, then yeah. Erica, she gonna have to know. Get some water in a flavor packet. Y'all, let me tell y'all something. She worked me. We got to go to the gym today. She worked me out so bad yesterday. I told her, I said, I don't know if I really like you. I don't know if I like you. I don't know if I like you right now. She was, I'm hurting right now. I don't know. I keep on having to stretch my legs because they hurt so bad. They hurt so bad. Y'all was in the gym. Y'all know I'm very dramatic. And so it would be somebody across from me working out. I'd be reaching out my hand like, she was like, please stop. I got my water right here. I've been doing really, really well with my water. She told me, I was like, Mariah, I don't think I want to do all this. She was like, you trying to look good in that dress or what? Get up and stop complaining. I said, oh my. She's really, Mariah's, for the most part, she's not soft-spoken, but Mariah's real chill. You know, she has a little of me in her, but she's kind of chill. But in that gym, it's like, ugh, who are you? Barchi, no. She be saying stuff like, do you need a princess? I don't know if you want a Mariah.
She is strict. I mean, we were in the gym yesterday for like two and a half hours, and she's like, 2.5 hours, this is normal. And I was like, okay. Oh, okay. Thank you, Shawty Red. Well, look at Red's comment. Parties are heading back to the courthouse, assuming this is going to be an end. This is going to be an end into the day. Would be shocking if it's a verdict. I'm gonna move this, y'all, because yeah, it's probably the end of the day. Good point, Ash. Princess, you gotta go. I really do appreciate having Mariah because like yesterday, literally I woke up. We were supposed to go to the gym at 5, and I was like, oh, Mariah, it's okay. Tomorrow's my late day. So I'll wait a little bit. But I woke up and then I looked at the date and I just got super sad. So it's really good having her. It's really good just having her to kind of push me. Like it's annoying now because I have to get used to working out again, used to going to the gym. But it's good having her. Very, very annoying. But I'm happy I have her. Yes, Key. I do. And she gives me accountability. So yeah. Me too, pretty. I would love it. I love having her as my accountability partner. And she really is a good partner in the gym. She really is. Oh, Amanda, this is a lot. They're securing the building for what? Where's my phone? What? Barchi, not now, baby. You're gonna have to move. Come talk to me later. What? 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 Why? Okay, I'm on X now. Yo. Y'all, maybe God said it's time to end this. Let me see what Turtle Boy's saying. He says, interesting that the O'Keefes chose not to invite Brian and Colin Albert after the closing statements today. Okay, Turtle Boy, what's going on? Y'all, nobody really saying anything. Oh, Jesus. The jury, thank you, Jay. I see the beauty in watching with 300 people. Everybody is giving us some drops, a little drops of something in here. Hold on. What Sue say? Let me go back to Sue. Hurry up. Okay, I don't see another update from Sue. Jaleesa said, I've been asleep. Now I'm up and scared. I'm sorry to wake you up out of your sleep like this. Ebony, uh-oh. Thank you, dearie. Okay, y'all, they're saying no jury. I mean, no verdict, end of the day. It's no verdict. It's the end of the day.
right, jurors. I understand you want to go home. It's been a long day for us.
It's lame as hell.
We appreciate everything you've done today. I do have to tell you those same cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. We'll see you Monday morning, ready to start.
This is some bullshit. See, they pissing me off already. Y'all ready to go home? Y'all ready to go home? They don't want it bad. They're not ready to. Mary's lazy as hell. They have pissed me off. You can't. This lady's life is on the line. You couldn't stay the extra hour. I done got pissed off. You couldn't stay the extra hour. You're ready to go home. Got us over here nervous, thinking it's probably a verdict, and y'all just ready to go home. They trying to go to that damn parade Sue was talking about. They want to go to that parade. They are ready to go home. Like, that pisses me off. I just like, does anybody take this case seriously? Why are you ready to go home? She got them used to leaving early. Kristen, you're probably right. You're probably right. They will not be deliberating over the weekend. And this is a mess. Claudia, wishful thinking. I hope so. They said, Shataka. They want to get on my TikTok because as soon as I get off here, I'm going to be on TikTok talking crazy. It's 4:30. It is 4:30. They're only 30 minutes past their regular time at this point. Well, hell, now I really don't know how this is about to go. I don't know how this is about to go. I don't know how this is about to go anymore. I wish they would have stayed to at least 5:30. This makes me feel like we've really got some people that are confused. I don't know what it is, but I'm not feeling it. I'm not feeling it. So, okay, y'all, that's our day. That's our day. I am going to go to the store so that we can prepare for Wind Down Fridays with myself and Miss Jefferson. It's going to be at 7:30 on my page and Miss J's page as well. We're going to talk about all the foolishness from this week. All the foolishness from this week. I think I am really upset. I am really upset. Claudia said the forms seem to be confusing. I wouldn't want them to rush through it. I don't want them to rush. I don't want them to rush. I ain't gonna lose faith, Caitlin, because I do firmly believe that God is the best thing for Karen is going to happen, and that's a not guilty. She didn't do this. Am I upset? I thought I was excited. I was like, okay, maybe the not guilty came early, but I do agree with Claudia. I don't want them to rush through this. This is someone's life that is on the line. This is someone's life that is on the line. I want to see not guilty on all three. Me too. I get that too. But I do understand they've only been back there an hour. There is a lot of information. There are witnesses, and they have to go through the science. I would want them to walk through it. And if I were on the jury and somebody was like, oh, I think she's guilty, then we're going to walk through the evidence. And we're going to go back and forth. We're going to debate. We're going to talk about it. So here we go.
Here we go. So I will see you guys. Hey, Alice, I will see you guys at 7:30. My page, Miss Jefferson's page. Bring your wine, bring your cocktails. Y'all know we like to sit back and have us a good time on Wind Down. They're gone, Alice. They just left. They're gone until Monday. So yes, I will see you guys later. Thank you so much for all of the super chats, for liking the live, for just keeping the vibes right in the chat today. But we'll be back at 7:30. Okay, I'm gonna get off because Key is really cutting the hole. But I'm gonna see you guys at 7:30, and we will discuss all of the moments, all of the aha factors. We'll probably talk a lot about the closing today. But I shall see you all then. Thank you all. So I'm pissed too, Ash. I gotta go take these dogs out and cool off. But I will see you guys then. Thank you so much. Bye-bye.